Number 31. Well, CD not received.
Are you an interim?
No, Lordship.
No.
No, Lordship. But Bongaigaon, my lord.
Yes, he is not an interim.
My lord, not in Intel.
Try to give a short date. Short date in the sense we don't have any very short date, but
My lord,
CD not received, issue reminder
7th or 8th? 7th.
7/5.
My lord. Oh, Lordship.
May I please, Your Lordship? Lordship, in item number 36 and 37, Lordship.
Yes, 36 and 37.
37, Lordship, we have filed additional affidavit in both the cases on 22nd, Lordship. But I just now have checked it, Lordship, which is not tagged with the record, Lordship. Can we call for the records, Lordship?
Affidavit, no? Good.
Additional affidavit, Lordship.
Okay, we are trying.
Lordship. Much obliged, Lordship. Much obliged.
May I please, Your Lordship? Lordship, I mention item number 3, Lordship.
Item
Number 3, Lordship, motion
Yes.
matter. Lordship, we taken up this matter after 2 weeks, Lordship.
after 2 weeks, but your petitioner is behind the bar. It is a charge sheeted case.
Case, Lordship.
Charge
Petitioner is
sheeted.
behind the bar almost 9 months, Lordship. Now trial evidence has not taken, Lordship. Now next date is fixed on 9th of June, Lordship. Charge has framed by the learned trial court, Lordship.
Then we will fix it after 2 weeks and we'll call for the scan copy of the
Right.
case record also.
Right.
Number 3 for scan copy of the case record along with the case diary. Registry will do the needful and fix it after 2 weeks.
Obliged.
May it please, Your Lordship, in item number 15, wait service report upon exponent number 3, Your Lordship.
Item number 15.
Not received, Your Lordship.
1/5, what you see?
Is wait service report upon exponent number 2, Your Lordship.
Still awaited.
Wait, Your Lordship.
CD also not received.
We need CD or case record,
Case record, Your Lordship, charge sheeted case.
charge sheeted
Noted.
case. Item number 15
Sashi received.
and case record is also not received. No? Whether it was called. CD, we need CD.
My lord, page 20, my lord, of the CD.
Is a charge
Charge
sheeted?
sheeted,
one?
Your Lordship.
Page 20, my lord.
Oh. 15 not pick up. Scan copy of the case record along with the case diary will
Minus.
call for. Registry will do the needful. Service be awaited till next date of listing. List accordingly after 2 weeks. Okay.
May it please, Your Lordship, Lordship, I'd like to mention item number 26 and the adjourn for 2 weeks, Lordship.
Here are you on interim? You are on interim. Yeah, we have
CD
received
not
it.
received, my lord.
Not received.
Not received, my lord.
26 CD not received. Issue reminder. Let the matter be listed.
22nd.
22nd
Second, May.
of May or 22nd of May.
20.
20.
Hmm.
20 May. 20 May, 28 May, 2022. Interim be extended till next date of listing.
Obliged, Lordship.
Item 1.
Wait, please, Lordship. It's a NDPS case. Petitioner is behind the bars for last 1 year, 4 months. My main ground is, Lordship, the grounds of arrest were not furnished to me. On last occasion, this honorable court asked me to produce the certified copy of the arrest memo and the notice. May I please?
Do they obtain certificate copy?
Yes. Okay.
Your petitioner's name is?
Petitioner name
Faiz
is
Ahmed.
Abu Muhammad Faiz Ahmed.
Otherwise, he is in custody since when?
1 year, 4 arrested on 21/12/2023.
21/12.
2023.
That means 1 year, 4 months.
Once.
এখানে পাৰিব না লিখিব 1 year 4 months in custody 21/12/2023 and innocent লিখিব no recovery. And what is the stage of the case as per you?
Stage evidence test. That evidence test.
Do you have any information regarding any evidence recorded or not?
Just sit my record.
Because we don't have anything at present. Yes.
Last date was fixed on as per this order, 15 to 25 for evidence.
15/2. We have received the
Is
15/2/25.
15 to 25. In the, as per the petition, yes, like that.
No, but is there any evidence recorded? We are not in a position to say because we don't have anything here.
That is not.
The evidence stays. Listed witness, how many listed witness?
There are altogether 8 witnesses.
8 listed
Eight
witnesses, evidence stage at লিখি দিব, evidence stage. আর বাকি গোস্বামী submission more or less same thing. আর ground হৈছে arrest memo, তাৰপিছত notice under section 50 and inspection memo, no ground of arrest, এইখিনি main. মিলাব পাৰিব না? And it is under whose satisfaction?
Satisfaction of special NDPS, special session
Special
judge
judge.
Karimganj.
Karimganj is Sribhumi now, I think.
And give me 1 second.
Special judge
Yes,
bracket NDPS
Session judge Sribhumi,
Sribhumi. Special judge bracket NDPS Sribhumi.
Obliged.
Lordship, sorry for interference, Lordship. One additional affidavit I have filed in item number 13, Lordship.
Item number
1313.
13.
Yes, then we will call to Lordship. Yesterday we have filed.
Yesterday.
Yes.
13, na?
Yes.
Okay, we are calling.
Item 2.
13 করিব না?
Yes.
1.
Me, please, your lordship.
Yes.
There are two petitioners here. They are behind the bar since 1 year, 7 months, 16 days.
1
and
year.
7 months and 16 days.
Hmm.
They were arrested on 9/9/2023 and till date, the evidence has not started. So, the first ground is the ground of incarceration. And the second ground will be that the grounds of arrest were not informed. And
Have you annexed anything in that?
I have annexed the arrest memo, which is at page 47. 46. Oh, yes, 46. And at page 47, your lordship will find the third co-accused. He was granted bail by this honorable court by judgment and order dated 5/4/2025 on the ground of incarceration.
Evidence is not yet started. The charge has already been framed. But we are not in a position to say anything because we don't have, do you have any certificate copy of the
No.
orders?
Then the records may be called for.
Because without anything, or otherwise also you have annexed one as memo undoubtedly,
Yes.
but 47 or 50, whatever, it's not been annexed. So we need the case record. And where from it has to come?
Session Judge Karimganj, Sribhumi.
Sribhumi.
Yes.
Yes, when it can be. And it will call by the registry only. but
Registry only.
still,
7
due.
months, first week of May,
First week of May.
7th of May.
7/5. All copies
Obliged.
can copy of the LCR along with the case day, registry will do the need for 7/5. Okay. And in the meantime, if you can obtain any other certificate copy of the 50 or 47, you can apply.
Item 4.
This is the lordship.
My lord, in this case, the present petitioner was arrested 8/2/2025.
8-2.
Yes, my lord.
Hmm.
What is happened, my lord? The police officials, my lord, apprehended one person named Farooq Ahmed and recovered some contraband. Now he, my lord, confessed that these articles belong to the one present petitioner and one Ahmed Hussain, my lord, who approached this honorable court, and my lord was pleased to grant him bail considering the violations of section 50, which is at page 24 in my lord's order. And I have, my lord, annexed the my notice which has been issued to me by Annexure 3, page 22. And also have the certified copies along with me, my lord, for lordships that is required. My lord.
You obtained the certificate
Yes,
copy
my
of
lord. Nothing has been recovered from me, my lord. In fact,
So you were also arrested on the basis of the statement made by the co-accused.
yes, my lord, Farooq Ahmed. That
Video. He got arrested on 8/2/2025.
yes, yes, ma'am.
Yet not yet charge sheeted, I
No,
think.
ma'am, it is only 75 days, 2 months plus, my lord.
Otherwise, commercial quantity.
Yes, yes, yes. Commercial quantity recovered from Farooq Ahmed, my lord, who was driving his vehicle, my lord. But nothing, my lord, so far, any kind of recovery that is not there. It is very, page 15 of the FIR, my lord. That is, last, second paragraph from the bottom, my lord, will find that part, my lord. All the police officials arrested, me and along with one another, my lord, but nothing objectionable material found against the present petitioner. May I just touch it?
Without matter, arrested on 8/2/2025. Nothing has been recovered from the conscious position of the accused petition. He got arrested in connection with this case only on the basis of the statement made by the co-accused Farooq. Only the statement made by the co-accused Farooq Ahmed. And Baki other 20. One order is there in 20, page number 24. Same order will be there. The certificate copy or grounds of arrest are not been mentioned. Grounds of arrest are not been mentioned. So same order will be there as page number 24. But and Mr. Goswami's submission will be more or less.
Lordship, I may just make one prayer. If I can get back the certified copies, my lord.
Yes, sure. I have already checked.
Yes, sir.
Same order, however. Yes.
Item 5.
Please, your lordship. This 43 days behind the bar, lordship. This is intermediate quantity, lordship, and accused has been arrested on 11th March, lordship. City motive call for lordship, along with the
CDB call for along with the FSL report.
earlier that may be given.
When you are 43 days,
43 days, lordship.
he is already 43 days.
Intermediate quantity. 6-5.
653.
No problem.
Item 6.
May I please, your lordship.
Yes.
May I please, your lordship. Yes. In this case, petitioner was arrested on 5/4/25 to this 20 days, my lord, in connection with the LBS case of intermediate quantity. 6.9 kg of ganja has been recovered from his possession, my lord. But the ground of arrest shows something else, my lord. I have annexed the notice, my lord, kindly page number 21,
21.
lordship.
Yes.
In this case, my lord, only petitioner is the FNM accused. And ground of arrest, my lord, is number 22. The sufficient evidence found against the accused persons.
Number two, the accused persons are related with the sales of illegal suspected narcotic drugs. But in the seizure list and in the FAR says that ganja has been recovered from his possession. Therefore, this ground of arrest, my lord, is the copy paste of some other case. Therefore, the requirement of 47 and 48 is not complete in this case, my lord. On that ground, my
Now,
lord,
see, otherwise, the question of narcotic drugs is there.
lordship.
Obviously, drug may not be drug the word, but narcotic substances is always there. Because ganja is considered to be the narcotic substances.
Lordship.
Narcotic may not be drug, but narcotic substances. For that reason, I don't find the entire grounds of arrest will be vitiated. I don't think so.
And the ground of arrest is from during number 4 during there, the word used there in the
Whatever we'll see to it.
What about a case study and
We call for the case study. CDB call for. It's a commercial quantity? No, intermediate quantity. We don't have any shortage. Yes, side action.
9-5.
Nine. CDB call for.
7th,
May I please your lordship.
Yes.
In this case, lordship, the petitioner was arrested on 16/5/2024.
16,
16/5/2024.
24.
24, lordship. Charge sheet was submitted on lordship 10/11/2024. Total cited witness is 10, lordship. Next date is lordship 27/6/2025 for consideration of charge. Now lordship may kindly come to page number 75. Arrest memo, lordship. Name of the petitioner is there. Number 1, Salimuddin. Now lordship may kindly come to the next page 76. My lord will find the inspection memo. And then lordship, next page is lordship, notice for information under section 50 of CRPC. No ground of arrest is there. I have the original certified copies, lordship, with me.
Submission के लिए लिखो. Got arrested on 16/5/2024. CS already submitted on 10/11/2024. And list of 10 numbers of witnesses have been cited as a prosecution witnesses. And when it is fair for charge for
Lordship, next date is written there 26/5, lordship.
26/5. 26/5/2025 for framing of charge. Yes. Bakishini, same type of grounds of arrest tonight. This is also case from Sri Bhumi, Special Judge NDPS Sri Bhumi. A case submission and order will be seen.
It is same.
Pardon?
86, 8, number 8.
Yes, lordship.
item 8,
It is also out of same FIR.
No, lordship, different FIR, lordship. Here, lordship, the arrest memo is lordship at page number 72.
It ahead of you.
Inspection memo is page number 73. And lordship may kindly come to page number 74, that is 47 BNSS notice, lordship.
Here also you have certified copy in this case.
These are the Xerox copy of certified copy. These are certified copy.
No, Xerox copy will not do. Certified copy do you have? Here.
I don't have here, Lordship. In my
Yeah.
office, it is there, Lordship.
Then it will not do. We have submitted these things, but these are not photocopy certified.
Yes,
We
Lordship.
need this. If you
Photocopy-
have the
yes,
certified copy
yes.
with you, then we'll pay. We can pay this.
If I kindly fix them tomorrow, Lordship.
Tomorrow may not be possible. Lots of matters are there in tomorrow. Maybe by Monday.
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 Okay.
Monday, Monday. 28. We're listing it on 20. You
Yes,
try to provide
I'm
us
having
the
the
certified
certified
copy.
copies, Lordship. I have already obtained, Lordship. I'm having this.
List on 28. Okay, we're listing it on 28.
Highly obliged.
And 7 will be disposed of.
Yes, Lordship. Highly obliged.
For the hearing, item 9.
9 and 10, we are paying some time, Lordship. It will be gone through by learned APP ECS Kaushik. So he is an other.
Who is there?
RR Kaushik.
Other question.
He is an other Lordship after some time.
What timing?
Lordship, I'm sorry, Lordship. In item number 7, Lordship, for CC next date is 27/6, Lordship. It is not 5, 27/6.
আগৰ পুচিটো আছিলে 26/5 কৈছিলো ন এটা 27/6
27/6, Lordship. I'm sorry, Lordship. Highly obliged.
Item 11.
9 আৰু 10 দুটা বেলেগ লিখি এখানে Yes.
May I click on it? Sorry. My lord, the petitioner before your lordship is in jail, my lord, in the respect of commercial quantity, my lord, since 27/11/2000, my lord, 24, my lord. My lord,
27/11
2024, my lord,
27/11/2024
24, my lord.
Here we have not received this thing. Oh, it's a case diary. Oh, acha, acha.
My lord, in this case, my lord, there is a development, my lord, during the pendency of this bail application, my lord, one of the co-accused out of the same forwarding report, my lord, granted bail by this honorable court, my lord. Lordship kindly will look page 33. Yes, my lord. My lord, I am for my lord accused number 2, Hussein Ahmed, and my lord accused number 3, Najim Uddin, my lord. This honorable court, my lord, granted him bail, my lord, at page 61 due to my lord illegal arrest, my lord.
61.
61.
You're saying 34, 30, which one? 61.
61 serial number, my lord, page number 61, my lord. I have submitted by way of my lord, additional evidence.
Additional.
Additional evidence.
Where it is being.
My lord, relevant page, paragraph, my lord, page 67, paragraph, my lord, 14 is the observation. 67 paragraph 14.
There we saw the 47 or arrest memo, etc.
Hmm.
So you have annexed here also your arrest memo.
CD is there, my lord.
Acha, it is. Let us see 46. Your petition is behind the bar since when?
Say,
28/11.
Yes, my lord, same, my lord, forwarding report, my lord. 28/11/2000,
148 days. Really.
yes, sir.
His petitioner is
No, madam.
Hussein Ahmed.
47 notice without ground of arrest. Inspection memo. Arrest memo is also there but without grounds of arrest.
For this present petitioner, Hussein Ahmed.
Lordship. And 50 and 14 notices will not be like that. Only arrest memo and 47 notice. Is the arrest memo another before that?
And otherwise, so far materials is concerned, there are materials.
That's it, yeah.
There are materials.
Commercial quantity materials are against positive also. In earlier pages 47 notices are there. 48 percent 50 shares, we have nothing.
The case to not is charge sheeted, huh? Charge sheeted case no. One. Only one more time. You can only put it from the 160. If it is charge sheeted, don't put that. And moreover, you can see the order, it is page number 62, right? Page number 62, same. Advocate on which is 28, 11 to 71, staying on the best. And other. Here also. We have not put this para, it is the charge sheeted para, we have not put it. So same order. No. You don't put because it is not charge sheeted. Page number 62 is the two. Page number 62 the two orders same. Same submission, same order. Okay, it will be discussed.
My lord, bail granted. Bail. Deep level.
Sorry.
Very appreciate. Lordship, a regular bail application, my lord,
Last
Sir,
time you were
charge
directed
sheeted
to
case.
some- Yes.
charge sheeted case, my lord, LCR scan copy.
LCR received, my lord,
that was
amicus
received.
curiae also present here, my lord.
Now, my lord, 236 days, and out of 7 witnesses, victim has been examined as PW1. till today,
230.
36 days, 7 months, 27 days. Lordship, FIR may be seen at page 13.
Out of 8 witnesses, how many witnesses?
Out of 7, one examined.
Only one.
Only one examiner.
That is the victim, madam.
Okay. Yes, want to show FIR.
FIR, Lordship. The vernacular, my lord, is at page 13. The FIR lodged by her father after 4.5 months, my lord, alleging that there was a relationship and the petitioner, on the pretext of marriage, my lord, raped her daughter, and accordingly she was become pregnant, my lord. And now, my lord, I'll invite lordship to 164 statement. That is, my lord will find at page 33.
My lord, perhaps not at 11 at this stage, my lord, as PW1 is already examined, my lord. She was also
Yes.
cross-examined by the petitioner also, my lord.
That is why, my lord, I am inviting my lord may check the, she is also examined before the court as PW1. Lordship may check the 164 and the statement.
That is the trial, my lord.
Now, my only contention is that, my lord, out of 7, only one has been examined during these 7 months, around 8 months, my lord, 8 months period. Now, there is no chance to conclude the trial within, my lord, in the near future. That it will take so much time. And my lord, fact is that there was love relationship. She is 17 years old at the time of incident, my lord, and it was consented. However, though she is minor, but she is about to major, my lord. It was consent, and due to love affair, my lord, that was there, my lord. In 164 statement, she has stated. There is no force. So, my lord, I am praying at this stage, my lord, I may be allowed to go on bail. I'll cooperate with the trial, my lord. At any condition, my lord may impose. It's my humble prayer, my lord.
My lord, I have the objection in this regard, my lord, to allow him to go on at this stage, my lord. Only victim was examined, my lord. If there are 7 witnesses, out of 7, one victim was examined, my lord. And in her statement, my lord, in her deposition, my lord, clearly stated, my lord, although there is love affairs, my lord, he has taken her to the hotel, my lord. He said that he will go to someone else, my lord. So, place, another place, my lord. But he has forcefully taken to her, my lord, hotel, my lord, Kamakya hotel, my lord. Therefore, he has committed the offense for several times, my lord, in the hospital, although she raised objection, my lord. And thereafter, my lord, another informant and medical officer is yet to be examined, my lord, material witnesses. And my lord, at that time also she was 4 months pregnant, my lord. My lord, my submission is that he may influence the witnesses, my lord, other witnesses, my lord. Therefore, I objected at this stage, my lord, for granting him bail, my lord. It's such a heinous offense, my lord. And because
I have also objection, my lord. Since only one report has been examined, my lord, the trial process will be late now.
my lord,
Instance, granting of bail is difficult.
my lord, date of birth is 8/7/2007, my lord. 17 years.
This minor.
She was minor, my lord. Deposition is clear, madam. PW1, madam. Her deposition was clear. Some of the witnesses may examine, madam. It is necessary to examine. Medical.
My lord,
Deposition is there. Deposition.
I click on. I click on.
Yes, any
My
other?
lord, for a moment, my lord, if your lordship pleases to Peru space 34. My lord, that is 164 statement. My lord, for a moment, my lord. মোৰ নাম আৰু ঠিকনা ওপৰত পোৱাৰ দৰে সত্য। মই যোৱা 1.5 বছৰৰ পৰা শৰীফুল ইছলাম নামৰ ল'ৰাটোক ভাল পাওঁ। মই তাৰ লগত 6-7 মাহ মান আগতে ঘোৰাগাঁও কামাখ্যা হোটেলত যাওঁ। My lord, here in the FIR, my lord, it is stated as 4.5 months pregnant. But she is stating that before 6-7 months, my lord, she went to Kamakya Hotel. তাত মই তাৰ লগত এক ৰাতি থাকিলো। পিছদিনা সি মোক ঘৰৰ ওচৰত এৰি গুচি গ'ল আৰু মই ঘৰত গ'লো। তাৰ পাছত মোৰ 1.5 মাহৰ লৈকে চয়ঞ্চ নোহোৱাত মই শৰীফুলক জনালো। সি মোক নিজৰ ঘৰত লৈ গ'ল। তাত মই 6 দিন থাকিলো। My lord, guardian allowed, my lord, there was consent, my lord. And somehow, my lord, marriage, my lord, not, my lord, taken place. Therefore, my lord, the FIR lost by the guardian, my lord. Now, my lord, only prayer, my lord. Any condition, my lord.
These are the
I
trial, my lord. matter of
I'll
trial,
abide
my
by
lord.
any
Any dispute,
condition, my lord.
In the cross examine also, my lord. He has also cross examined.
Lordship will tell you both
Whether they have taken their plea, my lord.
your
or
time
not.
will come. Let me finish. My lord, my prayer would be, my lord, out of 7, during the 8 months period, only one witness examined, my lord, and it will take so many, my lord, months. It may also take, my lord, few years also. So, my lord, Article 21, my lord, there is violation of Article 21. And my lord, on that ground, my lord, I am praying before this court, my lord, at any condition, my lord may impose any condition, I will abide by, my lord. Any surety or anything, my lord. And I undertake, my lord, I will not hamper or temper any witnesses or.
You're Mr. M. Ali,
Lordship.
heard Mr. M. Ali, the learned counsel for the petition, and also heard Mr. Ubi Sharma, the learned additional PP, appearing on behalf of state respondent. And Mr. D. Bora, the learned amicus appear. You are appearing on behalf of Mr. Mahajan. Appearing on behalf of Mr. N. Mahajan, the amicus curiae for the respondent number 2.
He's appearing for another amicus, other courts.
This is an application under section so and so in connection with so and so. Scan copy of the case record has already been received. Where is the same? It is submitted by Mr. Ali, the learned counsel for the petitioner, that the accused petitioner is innocent and he has not committed any such offense as alleged in the FIR. It is a fact that both the petitioner and the victim had love affairs, and out of the love affairs, they went together and may have some sexual relationship, but the same physical relationship was consensual, and there is no force, and there was no force on the part of the present petitioner. No force applied on the part of the present petitioner. Further, he submitted that from the statement made in the 160, but statement made by the victim under section 164 CRPC also, it is very much clear that the petitioner went with the victim by her own, stayed in the hotel, and thereafter she again stayed with him for 6 days in his own house. He further submitted that the accused petitioner is in custody since last more than 7 months. And out of 7 numbers of witnesses, only 1 witness, that is the victim, has been examined by the prosecution. And thus, there will be considerable delay in disposal or completion of the trial. Completion of the trial, which otherwise will violate the Article 21 of the Constitution post. Mr. Ali further submitted that the accused petitioner is a permanent resident of his address locality, and there is no chance of absconding on and also there is no chance of any hampering or tampering with the evidences of the other witnesses. As the victim oblique the vital witness of the prosecution has already been examined, there is the question of hampering with the evidence of the prosecution also does not arise. However, the petitioner is ready and willing to contest the case by appearing before the learned court below on each and every date to be fixed by the court. Next paragraph. Mr. Sharma, the learned additional PP, raised objection and submitted that the victim had implicated the present accused petitioner, and it is an admitted fact that the petitioner was a minor at the relevant time of incident, and hence her consent also cannot be considered as a legal and valid consent. He further submitted that from her evidence, it is seen that he forcibly took her into the hotel and also had a physical relationship with her under threat. If he is allowed to go on bail at this stage, the probability of hampering or tampering with the evidences of other witnesses also cannot be denied at this stage. Next paragraph, Mr. Bora, the learned amicus curiae appearing for the respondent number 2, also submitted that the victim was a minor at the time of her incident, and at the same time, it also cannot be denied in regards to it also cannot be submitted that the probability of hampering or tampering with the other witnesses also cannot be denied at this stage. Mr. Bora accordingly raised objection in allowing the accused to go on bail at this stage. Next, hearing the information made by learned counsel for both sides, I have also perused the case record, the statement of the victim recorded under section 164 CRPC, as well as the evidence recorded, as well as the evidence of the victim recorded as PW1. It is also a fact that the accused petitioner is behind the bar for a considerable period, and only one witness oblique the victim could be examined by the prosecution till date, and hence the probability of completion of trial within near future also cannot be expected at this stage. Next paragraph. Considering all these aspects of the case, and also considering the statement made by the victim under section 164 CRPC vis-a-vis in her evidence, I find that Further custodial detention of the present petitioner may not be required. And accordingly, I find it a fit case to extend the privilege of bail to the present petitioner. So and so for report. Their condition ketaman di dibo. It is pending before in which court? Morigaon.
Morigaon.
Session Judge
Special
Morigaon.
judge Morigaon.
Special Judge Morigaon to the satisfaction. Okay, you are granted bail.
Obliged, my lord.
I say legal affidavit. I was. It's lying defective. Your affidavit is lying defective. in fact.
Otherwise, I have the certificate copy of that.
No. Your affidavit is lying defective.
Yes, Lordship. Otherwise, the documents we have annexed, I have the certificate copy.
Now see, you, those
Yes, Lordship,
documents you
that-
have
that
already
Lordship
filed
can
to
be
an
at
additional
2 PM,
affidavit.
Lordship, 2
Affidavit
PM.
is this lying defect. So you just correct it
Yes,
and
at 2 PM, at 2 Lordship.
2 PM what?
At 2 PM today, Lordship.
2 PM will do. Correction হয়ে যাব নি?
In affidavit, I will rectify, Lordship.
Okay, we have to appealing at 2. You are for the amicus? Oh, we have to. Oh.
May clear, sir. It's for an NDPS case, my lord, regular bail, my lord. The petitioner was arrested on 3/11/2023, my lord. Already 1 year, 6 months is running, my lord. And the
3/11/23.
1 year, about 6 months, my lord. And the ground of arrest has not been communicated, and the case is charged and charged frame, my lord. And at this stage, evidence stage, my lord, but not a single witness has been examined, my lord.
I have the record also not received, my lord.
Oh.
Office not received, my lord. 14. Yeah. Record not
Not received.
Scan copy.
We need the record, in fact. Have you otherwise filed any certificate copy? As you have taken steps, grounded
Additional
arrest Momo was not, the grounds of arrest were not furnished to you, whether you have filed any,
No, my
then we are not in a
For
position
that
to
may
say.
be given, my lord. Call for the,
Where from it has to come?
my lord.
Which district it has to come from? Which district? Kamrup.
Metro, my lord.
Registry note to আছে নেকি? নাই অহা ন? Not been received. Because as per office note dated 22/4/2025, the scanned copy of the case record is not yet received by the registry. Issue reminder. The registry will do the needful. Issue reminder directing the learned trial court below to send the scanned copy of the record on or before the next date of listing. On or before the next date of listing. Registry will do the needful. List accordingly when it can be listed, yes. It has to come from Kamrup Metro.
Metro, my lord.
It will come for registry, my lord.
No, you want any date, that can be first week of May, 6/5. 6/5.
May it please your lordship, the application is a retired headmaster and is 70 years of age, lordship. Section 10 of the POSCO is added here, lordship. Kindly peruse the FI,
Section 10.
lordship.
Yes, what is the position where
My lord,
the
here,
notice is?
Hello.
LNPS. lordship.
No, notice served only. Service is still awaited.
my lord, here, charge sheet submitted, my lord.
Oh. Charge sheet already submitted. Your petitioner is behind the bar since when?
Lordship, since lordship, he was arrested on 24 to lordship, 60 days, lordship.
60 days.
He is about 70 years of age, lordship. Otherwise also lordship, he was a retired principal lordship and he was.
That is more, more thing,
Lordship.
bad thing to, but I mean,
Yeah.
here it is more. Because
considering
being
the
a principal, if he indulges with this kind of things. it's-
Let him appear before the court, madam.
Obviously, he will
Fine.
appear. Now, he is in custody, obviously, if
Fine.
he's in custody.
He is in custody lordship.
Madam, third sheet number is 13 of the
CS number,
13 of the 25,
লিখে রাখো এ। দেখো, সার্চিট নাম্বার
13 of the 25.
13
13, madam.
13/2025 dated
There is 28,
28
8.
3 এইটো লিখি দিওঁ, CS has already been submitted, লিখি দিব পাৰিব ন? And is directed to appear before the learned trial court below with a regular application of way which may be considered in accordance with. You dispose for it. You appear before the learned trial court below because section. No, behind the bar, you, I mean, approach the learned trial court with an appropriate application for bail, regular bail. That may be considered, I think. Considering all these aspects, especially his age or whatever.
Lordship. Oh, no.
So otherwise we are disposing the matter.
Lordship. No more power.
বাকি অর্ডারটা পারিব না লিখে? Yes, we'll giving a direction.
Lordship.
We're giving a direction.
Obligation.
CS নম্বরটা লিখে রেখেছে না? Dated 28/3.
17.
Madam,
17. May I please your lordship?
Just a second. Yes.
madam, RJ Burgo, madam.
Which one?
After some time, madam. 17.
RJ Porwa is dealing with this case.
Madam, he is in another court, madam. He will come, madam. He has gone from madam already.
Okay. Otherwise, it's a case of
EAP lordship.
UAP.
Lordship.
18.
Wait, please, खाली madam, we will pass over for time being lordship.
Madam, here CD was called for, madam. He did not receive, madam.
43 days behind the bar.
How many days?
43.
43 days. It's a
22
case
B,
of
madam.
22.
22 B, madam.
Short date you are
Sorted,
finding,
madam.
29 it can be given on the 29.
Madam. First, madam. First.
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 We'll issue reminder, call for the case diary along with the FSL report. First,
CD along.
yes, first of me. We get list.
Obliged lordship.
19.
19.
Yes, Mr. Amani.
May I please your lordship? This is a regular bill lordship. Okay, we find the FIR on page 15 lordship. The typed out copy. And originally is on page 18 lordship. Lordship, both are in English lordship.
Okay.
Let us come in 15 lordship. Yeah, lordship. May I read it lordship? With reference to the subject cited above, I have the honor to inform you that during second week of March 2025, one officer of technical work, Sri Nikibuz Jaman, the present petitioner lordship of Fakiragram Municipal Board, visited to the site of renovation of work of commercial building at Fakiragram Main Road, Ward number 70, of our store, namely Dasakarma Bandar. On that day, he asked my father, Sri Ashwini Roy, whether he had applied for permission for renovation of construction work of commercial store. Since my father was not aware till that he has not applied for permission, then Nikibuz Jaman suggested us to apply for permission for renovation of construction work at Fakiragram Municipal Board. Since my father is very old, so he have authorized me to visit at the Fakiragram Municipal Board. In this regard, I visited Fakiragram Municipal Board. After 2 days of visit, Sri Nikibuz Jaman at the site renovation, Sri Nikibuz Jaman apprised me that a total amount of 17,500 would be incurred. Again, I met him at his office, Municipal Board, on 14/3/2025. On that day, I discussed him about the document required to be submitted at his office. Also, I requested him to reduce the cost of permission from 17,500. Finally, he reduced to rupees 15,000. Later, yesterday also, I submitted the application officially on behalf of my father, Sri Ashwini Roy, for renovation work of commercial building at Fokiragam Main Bazaar, ward number so and so for our store Dasakarma Bhandar. My father has signed in the form of application for the permission for renovation and construction work. Accordingly, I, on behalf of my father has been corresponding at the Fokiragam Municipal. Yesterday on 25/3/2023, when I asked whether I will get the money received against the amount to be paid him, the public servant Nikibul Zaman stated that he will give receipt of an amount of 2,000 to 3,000 only. That can note it, Lordship, 2,000 to 3,000 only. The rest amount have to be paid consultancy firm. This is important, Lordship. The rest of the amount has to be paid to the consultancy firm against the drawing of the construction site and also the bribe to manage the other step, Lordship. As I am willing, I'm not willing to pay the demand bribe, and therefore I approach the Director of Vigilance and so and brief them the demanded rights by the public servants in Nikibul Zaman of the municipal board. Then in recording the device provided the Director General Activity, I have recorded the bribe demand conservation office staff for the technical of the Fokiragam municipal board who helped me on the 25 so and lost this event. Now the question is that Lordship will have the query that whether permission is required for renovation or alteration of the building, as we have heard that is requiring while new construction, Lordship. That, Lordship, I want to point out, Lordship. This is the first query, Lordship. The whether, as I also have heard, Lordship, since long that the new mobile tool. Lordship will see the heading, Lordship, in the very first. In the heading, Lordship will be very first, Form 1, application form to erect, re-erect or to make material alteration in a building, Lordship. That is the renovation, Lordship. For renovation, it is clear that for renovation, Lordship, permission is required, Lordship. And for that permission, Lordship, the construction site, Lordship, the plan map should be sketched, Lordship. And that has to be done from a registered firm. And that day when the petitioner is a junior engineer in the municipal board, Lordship, when he suggested them to obtain the drawing, Lordship, then they said that you do it yourself, will pay the amount, Lordship. It was the petitioner duty to produce the Lordship drawing of the renovation, Lordship site. This is the duty of that person. But he have shifted the burden on me and said that you often, everyone, you often this one construction drawing, and together we pay it, Lordship. That Lordship have gone through it, Lordship. 15,000 was demanded, Lordship. Lordship will kindly see page 25, Lordship will kindly see. Page 25, but only the mistake is done that the registered firm, Lordship, the owner, the proprietor, Lordship, is my wife, Lordship. That is my only mistake. It is taken as, Lordship, that she is the owner of that firm, Lordship. She is a registered owner. Her site is applicable in the permission, Lordship. And for that, Lordship, they have charged 10,000, Lordship. Lordship will kindly see. This is the original money received. This is the original money receipt which they have not taken, Lordship, because they have already filed the FIR, Lordship. There is clearly. And
But
now,
he refused to pay, then why from where from it is money received has come?
Lordship.
As he refused to pay and then he approached to the anti-corruption.
Along with the, Lordship, the drawings, that bill was furnished, Lordship.
It was not paid.
Not paid. Lordship will kindly see the next green color flag, Lordship, of that Gazette notification. And that 10,000 has gone, Lordship, out of 15,000. 10,000 has gone, Lordship. Now remaining 5,000 is there, Lordship. Demanded 5,000. Lordship will kindly see the green flag, Lordship. The rate of the GMCS, Lordship, the charge, Lordship, municipal board charge for the construction, Lordship. Lordship will kindly see the second part, Lordship. That made in a table, Lordship, the type of construction and rate, Lordship. Commercial, 4-time rate of the residential RCC residential lordship. That in the FR it has been clearly mentioned it is a commercial and it is in the main lordship near the main near the main road in the main bazaar lordship. In the FR itself says the location of the site lordship. So it is purely commercial lordship, though it is a store lordship. The rate includes nursing home, hospital, marriage hall, community hall. Lordship will kindly see 40 rupees per square meter. And lordship, the second lordship will see the rate. Industrial godown warehouse 8 times of the RCC residential lordship. 8 times higher, the rate is higher than the residential RCC building lordship. That lordship will kindly see lordship in the right side lordship of the column lordship. That the ground floor 80% per square meter and upper portion 96 are valid. That is the lordship rate of the rate, and after concluding lordship entire area lordship, the amount counts around 3,000 to 5,000. That was not fixed, so notice was not issued lordship. So it was fixed in a lump sum 15,000. It is the case lordship, and he have already lost the case, and the person is behind the bar for last 30 days. This is the case. And the punishment lordship 7A is there. It is not less than 3 years, maximum to 7 years. Already 30 days. Money was not paid earlier lordship. It was a trap case at the time money was delivered. There's total lordship 10,000 for the drawing, and remaining 5,000 it was not calculated. He said approximate 3,000 to 5,000. This is the case. Where comes from the bribery? Only my part is that the farm belongs to my wife lordship. That is my, if lordship says, then that is my offense. Otherwise, no case can be made out of from this law. 15,000, 10,000 for drawing, and 5,000 regarding that which was not calculated the entire lordship area. The delivery was not there prior to that lordship. It was a trap case. He says that amounting to 15,000 it will come. That clearly reflecting the FR he himself said. The entire thing is lordship. I do not deny the entire thing what has been stated in the FR except the last part. And that thing is clearly lordship mentioned in the FR. So I have no denial to the contents of the FR lordship because I demanded 15,000, 10,000 for that construction lordship that drawing, and 5,000 will come around. In between, it will not exceed 5,000 after calculation of the total area. The rates are already given. It is published in the Gazette lordship. That the informant might have misunderstood this thing. This is the case. 30 days is a junior engineer, also local person, no chance of espionage. I'll cooperate in every step whenever police call me, and I have placed my case lordship will clearly understand it. This is the case.
So, that proceeding for initiated because the accused prisoner demanded 57,500. After negotiation, it was reduced to 15,000. So one day he was called and paid 10,000, and then he was not paid handed with that 10,000 rupees. So he has said, as per his statement, he has said that it was for construction plan. The second money.
No, but what's his statement is the real Jain statement.
As per his statement, building permission fees and consultation fees. When the property tax means fees total including 15,000 as per his statements. And on that day he was asked to come and paid rupees 10,000, and he has got returned that also. Only thing is that pending part is the voice identification verification process and recorded conversation between the victim and the accused has not been completed yet. That part is investigation part is pending also. And
Voice recording is there.
voice recording between the accused and the informant also. And FSL also said that sample of
The report is not
report is not here. I think it was got written there. Everything is catching the FIR and receiving the case there.
For that bill, 10,000 was delivered lordship. And regarding that total area after getting the drawing lordship, totally square feet will come out lordship. Then the collection, and one thing I have forgot to submit, including in that 5,000 lordship, property tax also there lordship. Because in that remote area tax are not paid lordship, that including all lordship, he said lump sum 5,000 will come lordship, official expenses. Official expenses mean property tax, the rate which I have shown Lordship in the green flag, that all together will be calculated, and thereafter he says that approximate it will come within 5,000. Initially, he thought that it will come higher, so he said 17,500 Lordship. Later on, Lordship, when it was calculated roughly, he said that it will come under 15,000.
The thing is that he is a junior engineer of the municipal board. Whether he is responsible for other service or not for this.
The plan and approval are done by the junior engineer only. Lordship, site after site verification, that clearly FIR every word I admit, Lordship. Every word of the FIR I admit, Lordship. What happened? The actual fact is given last part, Lordship. Due to his misunderstanding, Lordship, we have lost this FIR to the police. Lordship. No denial, not a single word I deny, Lordship, except the last paragraph. The construction site was visited. I asked them whether you have obtained any permission or not. Then they contacted me. Father being an old person, he said that my son will do. Everything I admit, Lordship. That 15,000, everything. That receipt is there. Only my fault is that farm is registered in my wife's name. That is, if Lordship consider, that can be my fault, Lordship. Otherwise, it is two separate establishments, Lordship. It is a registered farm. My wife runs it. She is also an architect, Lordship. She runs that farm, and I am a GMC, Lordship. Because of better understanding, Lordship, if somebody said, then we refer name to that farm, Lordship. That may be out of officially, Lordship will say that I have mistake, but normally it does, Lordship. If somebody comes and says that where we will make prepare the drawing, then we say my wife is there, my wife farm is there, you can approach there. That is the Lordship. Normal, Lordship, human nature, Lordship. That Lordship.
Heard Mr. Esponi, the learned counsel for the petitioner. And also heard Mr. D.B. Goswami, the learned additional PP, appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so. CD received, where is received. Next slide is submitted by Mr. Munir that it is a fact that the accused petitioner is a junior engineer in the municipal board. And it is also a fact that he when the father of the informant approached the present petitioner for getting some permission for his renovation work of a commercial area, he undertook that he would help him in obtaining the permission for renovation, and also charged an amount for the same. It is also, he further admits that as per the statement made in the FI, he asked to pay rupees 15,000, and including the drawing, etc., from any registered firm, as well as the other expenses for the permission to obtain the permission from the municipal board for renovation of the commercial building. Mr. Munir further submitted that as it was a commercial place, the rate was higher than the residential plot, and accordingly, in a rough estimate, it was the cost, including the property tax, etc. He charged for rupees 3,000 to 5,000, and for drawing, for the construction drawing, etc., from the registered firm, it was charged for rupees 10,000. However, it is also a fact that the registered firm, which is running by his wife, demanded rupees 10,000 for the same. But due to some misunderstanding, the present petitioner, the informant, lost the FIR, and it was a trap case when he prepared the money receipt also for rupees 10,000 from the said firm. The present accused petitioner is behind the bars since last 30 days, and hence I also got sufficient opportunity to interrogate him, keeping him in custody, and hence further custodial interrogation may not be required for the interest of the investigation. However, the petitioner is still ready and willing to cooperate the IO in further investigation of this case if he is granted with privilege of bail. Next, Mr. Goswami, the learned additional BP, raised objection and submitted that the present petitioner was charging for rupees initially for rupees 17,500. And then he reduced the same to rupees 15,000 and rupees 50,000 full stop. Being a junior engineer of the municipal board, he is not authorized to work for this to obtain any permission on behalf of some other person, and he was accordingly trapped and caught red-handed while he was taking bribe of rupees 10,000 from the informant. Mr. Goswami further submitted that the voice sample, which was the voice sample, that is the conversation recorded between the petitioner and the informant, has already been sent for examination to FSM, and report is yet to be collected by the IO. Next paragraph. After hearing this submission made by learned counsel for both sides, I have also perused the case diary, and it is also found admitted that 15,000 was asked by the present petitioner for the completion of work of permission, drawing, etc. from the informant, oblique father of the informant. However, considering the other aspects of the case materials in the case record, case diary, I find that further custodial interrogation of the present petitioner may not be required for the interest of the investigation. আর বাকি একটা লাইন পেপার মোর ওই বলতে সব সাইডিং না allow for you bill to allow for you. Okay, you are granted with bill.
Special judge, Lordship, Assam.
Special judge Assam. Special judge Assam. We'll make some observation there, but otherwise it is a
Much obliged, Your Lordship, much obliged, much. But may I have that gazette? Lordship?
yes. Oh yes, 17 to material.
17.
May I please,
You are looking after this CD, that's why we kept it as well.
may I please, also petitioner behind the bar as on date lordship 70 days lordship, arrested on 14/2/2025 lordship. There is no any allegation in the FIR lordship, but in forwarding report lordship, alleged that the petitioner is a linkman of ban organization Alpha lordship. It is true that petitioner is the small shop lordship, and which is situated near Assam Nagaland border lordship. Sometimes some extremist group came to his house and forcefully used his mobile lordship. That is
His
admitted
mobile.
His mobile lordship. That is admitted fact lordship. And he is not associated with the Alpha organization lordship. He is the shopkeeper lordship. Sometimes it is admitted. I have admitted lordship. And today as on that 70 days lordship. And one of the similar stated person earlier approached this honorable court lordship regarding the linkman lordship. Thereafter, this coordinated basis of this honorable court release on bail lordship. I have a copy lordship. Moreover, lordship, the ground of arrest in arrest memo is not communicated lordship. I have a arrest memo lordship. There is no any ground of arrest lordship communicated statement. Therefore, my humble peer will sadly allow his own bail lordship. One Shahabuddin, also a similar stated person, he is a ground worker in Alpha organization. Thereafter, this 14 bails of this honorable release on bail. One Sujit, they also release on bail. Similar stated person. The other petition also similar stated person. And ground of arrest also not communicated to the present petition lordship. I have submitted the arrest memo. lordship.
Benches are available here.
Lordship, I have submitted.
Coordinate benches are available here. You only
Yes, Lord.
filed the arrest memo.
Lordship.
You have only filed the arrest memo.
Arrest, this I have submitted on arrest memo lordship. That's not
Only arrest memo I have collect lordship, maybe in CD lordship.
Some application, my lord, rejected by the, my lord, coordinate bench, my lord.
No,
The allowed by the coordinate bench, my lord, and one application is rejected by this honorable court, my lord.
one application is here
One
only.
application, my lord. His name is, my lord, that order I have from my, Tofa Kondok, man. His
Oh.
bail application was rejected on 17/3/2025.
Now lordship, as per information lordship, that Pak only have lordship granted release on bail by the trial court lordship. Maybe started lordship. I have just now information received lordship is released on bail by the Lanet trial court lordship. Court below lordship.
So now you are appearing for Tafakon now.
No, lordship. I am appealing for one Sanju Das lordship.
But coordinate benches orders are there.
Yes, lordship.
Bench order, my lord, allowing the bail application, my lord.
Acha.
And this court, this honorable court order, my lord, rejecting the bail application.
Maybe.
But it comes to special act, my lord, because we have cleared there.
Maybe lordship, earlier, I have other bail application, order also, coordinate all bails of this honorable granted bail. Same PUP act lordship. That one earlier lordship, honorable justice, retired justice Ajit Bortapur, and another is honorable justice Monish Chaudhary lordship. And the another was honorable justice Mrs. Justice Susmita Kokon Khan lordship. And another lordship, honorable justice Arun Dev Chaudhary lordship.
So you want to, what plea you want to take?
Lordship, I am very lordship kindly consider the petitioner on that ground lordship. There is a similar stated person lordship. There is a
On the ground means non-communication of ground of arrest.
communication as well as lordship already 70 days behind the bar lordship, and he is not associated with the alpha lordship. And only it is a admin fact. Sometimes the alpha lead came to his house and used his mobile lordship. This is admitted fact lordship. And further, he is not linked with them lordship. Therefore, and a similar stated person also release on bail this honorable court lordship. As far my humble paper finally consider above the aspect lordship.
Lordship, may kindly come to page number 14 of the bail application.
One from.
Page number 14, my lord, paragraph number 3, my lord.
Yes.
Paragraph, my lord. These are the, my lord, materials, my lord, collected during investigation, my lord. That is also released from the case diary, my lord. Because he has got, my lord, direct link with the, my lord, cadre of the NSC and Kam Alpha, my lord. And this most important, my lord. I'm just reading the line, my lord. The accused Sanju Das has stated that his task was to give information, my lord, the names and phone numbers of the potential targets to Alpha and NSCN for extortion demands to facilitate movements of Alpha. For that reason, my lord, during investigation, my lord, he was arrested, my lord.
Apart from that, the ground of arrest also not communicated lordship at the time of his arrest lordship. That aspect may be considered lordship. In arrestment, there is nothing, there is no anywhere written as a ground of arrest, nothing lordship.
No, you submitted only arrest memo. I'm saying.
Maybe it is, it is. Yeah,
Mm, 47 is there or 40?
47 is there, my lord. He is, my lord,
Grounded.
compliant, my lord, but not
Arrest.
as part of my lord, Nyan Kuaman. Is there? We do. Investigation is still going on, my lord.
Mm,
There
Yes.
are, my lord, some other accused persons who are yet to be arrested.
Yet to be arrested.
Regarding down the arrest, my lord, I'll go by the record, my lord, whatever record says. my lord. Materials collected, my lord, already I.
I think the ground of already dishonorable court granted bail, let's say, I, provision also dishonorable. Non-compliance of the mandatory procedure. Only this ground loss may be considered loss.
You, Mr. B. Islam,
Be Islam loss.
heard Mr. B. Islam, the learned counsel for the petitioner. And also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so CD received to various the same. It is submitted next para. It is submitted by Mr. Islam that the present accused petitioner is innocent and he is not an extremist, not associated with any extremist organization Alpha or NSCN. However, it is a fact that he has a shop wherein sometimes some extremist people came and for and forcibly used his mobile handset. But that apart, he is no way connected in the alleged offense. The petitioner is behind the bars since last 70 days, and hence, considering his preemptive detention also, he may be released on bail. Mr. Islam further submitted that while issuing the notice under section 47 BNSS as well as the arrest memo, no grounds of arrest were communicated to the present petitioner in any written form, which which violates the mandatory provision, which violates the provision of Article 21 of the oblique 22 subsection 1 of the Constitution of India. However, the present petitioner is ready and willing to. He also already Bihan Kumar cited probably. He further submitted that the present petitioner is still ready and willing to cooperate the investigation, cooperate the IO in further investigation of this case. Next para. Bihan Kumar Suman probably. Mr. Borwa, the learned additional PP submitted in this regard that there are sufficient incriminating materials against the present accused petitioner, and he is one of the prime accused, and the accused full stop. The role of the present petitioner was to get information and the names and the phone numbers of the potential targets, and also to facilitate the movement of Alpha. He was totally associated with the extremist organization and also helped in demanding money, extortion, or kidnapping, etc. He further submitted that the case is still under the stage of investigation, and some other culprits are yet to be named in connection with this case. Accordingly, Mr. Borwa raised objection and submitted that it is not at all a fit case to grant bail to the present accused petitioner at this stage. Yes, Borwa, otherwise we don't have any alternative. The grounds of arrest is admittedly it's not communicated. Otherwise, it's a very serious offense. In fact, the kidnapping is also related with this. So if such kind of offender is released on bail, then you can see what will be the position.
This probably my lord before my lord the Bihan Kumar judgment time, my lord. Now we are my lord circulating the Bihan Kumar judgment, my lord, to the various police officers, my lord. And my lord, our my lord PP and higher authorities, they have also circulated, my lord. So we are.
No, I have also, it was also informed to me that in recent cases, most probably the steps were taken at present. But see, some of the veteran criminal has already been released. So probability of getting back into the team is it's not possible, I think. Especially NDPS case, you won't get them. You won't get them. Gone forever. No way. Is a case of which, please?
So special, just sorry, the lordship.
There will be some strict condition, my lord, if you will
Yes,
appear before
please.
time,
Condition,
my lord.
lordship.
At least, my lord, twice in a month, my lord.
Lordship.
Till the completion of the.
Yes.
Lordship, any condition. I will-
Twice in a month করে দিব, huh? You will appear before this one. And special just Soraida, special just Soraida.
Much obliged.
আমার কপি দিয়ে না নাকি? আপনার কাছে
I raised 2 pointers, 47 and 48 minutes. Your lordship directed to produce them the scan copy, but I have.
Scan copy also I have flagged all those.
Certified copy.
MON. 47.
My lord, in the FSL report also, it is just presence of the heroine. There was no mention what is the quantity of the presence. Just presence of heroine.
In FSL.
47, your lordship will find no ground of arrest has been given. That is not the case. That is. They are improving, of course, nowadays. They are now doing it, but it requires more time for the better suggestion. Now there is a guidance from the director of prosecution, I think, but they are doing it. So I pray for his bail, madam.
Otherwise, your petition is behind the bar since when?
89 days, madam. Since, madam, 26/1/25.
26/1/25, 89 days. Intermediate quantity. Terms of the quantity of the presence of quantity of heroin present in the contraband is not specifically mentioned in the FSL report. The data ground liquidable. And 89 days in custody. Our cases 47, 48, 40, 50 more grounds of arrest. Number 4 to say is a court commercial quantity, so record of section 37 not traffic. It's not commercial quantity. So record to nahibo, baki hin otherwise.
And charge sheet on 21/3/25.
Charge sheet on 21.
21/3/25.
21/3/25. Charge sheet.
And 22/4/25 is next date. One it has gone with first production and CC. Consideration.
It's a case of which place?
Kachar.
Still means Kachar, Silchar.
Yeah.
Special just Kachar Silchar.
What is the amount? Amount
Amount will be Maybe 50 or 1 lakh,
Yes. Developer.
50,000 maybe.
Twenty-one.
Make reason also.
Yes.
A regular bail application, my lord. POCSO is involved, my lord. So we took notice of the steps of notice upon respond number 2. That service report is awaited, my lord, and CD is also not there. So, my lord,
Service is awaited.
it is a bail matter, my lord, if an amicus can be appointed, my lord.
But if they engage the other, that is one of the other, we can reflect one thing otherwise. You make an inquiry regarding the service of notice. In the meantime, CD, it's a not a charge sheeted case.
No.
No. How many days your petition is behind the bar?
But I was, my lord, this is a third matter, my lord.
Or
Charge-
charge sheeted?
charge sheet, charge sheet.
Folks can copy it to actually keep a building call for a bull side. Case diary দিলে কারণ registry step one আছে না? It is later as case diary না? That's why registry has not taken any steps. Mm. Can copy of the case record along with the case diary be filed for registry will be deleted. Service is still awaited for the response number 2. Done with additional people, Mr. Goswami is hereby asked to take instruction regarding the service of notice on response number 2. If the service is completed and the petitioner, the respondent number 2 remain unrepresented, the amicus will be appointed accordingly. List. 8-5. What is the stage of the case? Do you have any idea?
Probably, my lord, charge is yet to be framed, my lord.
Yet to be framed?
I have to take instruction, my lord.
We have, otherwise we are fixing on 8-5.
My lord.
22.
Have 6 submitted.
It is also a case of this POCSO.
POCSO.
Otherwise, you are appearing. Anyways, case has already been charge sheeted. So your petitioner is behind the bar since when?
Since 13-3.
30,
13-3.
13-3. More than 1 month. So we are not going to record any objection here at present because search sheet has already been submitted. He will appear with the regular application for bail. Heard Mr. Estes, the learned counsel for the petition, and also heard Mr. DP Goswami, the learned additional PP, appearing for the state respondent 1, and Mr. MK Das, the learned counsel, appearing for the respondent number 2. You are not an amicus, you are appointed for the respondent number 2. Or Baki, so serious CS number?
CS number 121/25 dated 18/4/25.
So we'll ask you to regular bail application. Let us see that. No. That was case is disposed of.
Highly of
23.
Regular verification object. CD was called for on last. Received a case diary object. Today is 33 days.
You have not received the case diary?
Not
Not received. It's a case of NDPS.
Intermediate. Yes.
So today he is in 33 days.
Lordships.
Tell us a date.
So 6/5.
6/5. 6/5. Issue reminder. Okay, we are listing it on 6/5.
Time being 9 and 10.
9. Yes.
May I please say, Lordship? The
9 and 10, you are appearing for both 9 and 10 or
For both 9 and
both
10.
9 and 10? Out of same FIR?
No.
Different.
Lordship, the petitioner for item number 9, Lordship.
Mm.
The petitioner is booked under section 21C and 22 of the NDPS Act, arrested on 13/2/2023. As of today, Lordship, it is 800 days, 2 years, 2 months. And there are 8 listed witnesses, out of which only 4 have been examined till date. Lordship.
8 witnesses.
Yes. 4 have been examined till date, Lordship. Lordship, I have taken the plea of the grounds of arrest, Lordship, which has not been mentioned in the, I filed an additional affidavit with regard to that, and which has not been mentioned in the arrest memo. Lordship, arrest memo is at page number 30 of my additional affidavit. And along with this, the scan copies are being called for, Lordship, including the arrest memo, the notice under section 50 of the CRPC, as well as the W2 message sent to the family members of the accused person, Lordship. Nowhere conveys the grounds of arrest, Lordship.
Page number 31. Yes. 130 is arrest memo.
30, page number 30 is the arrest memo. There is no mention of the ground of arrest, Lordship.
So you have annexed only arrest memo.
I have annexed the arrest memo. Along with this, Lordship, scan copies has already been called for. And in that.
Every flag mark.
No. But the 50 CRPC 50 is there. May I?
This letter recent letter active. Yes, not by one, I know how it's actually my son and what the friend is going to do. তারপর দেখা করে আমি দেখ বা দুটার মই লৈ যাম তো দুটা ভিতৰত ৰেডি ৰাখিলে হ'ল বিসিটো লৈ লম বিসি এটা লৈ লম চেম্বাৰ
Okay, these 2 pages contains the section 50 notice.
Your petitioner's name is
Anupam Ambar. Yes. Both the notices does not convey the grounds of arrest, Lordship. Lordship is well aware of the Bihan Kumar and Prabir Purka's judgment, Lordship. And considering the length of detention, Lordship, it's been 2 years, 2 months.
2 years, 2 months, 800 days, 8 witnesses, 4 examined.
Lordship, now they make one submission here. Lordship, here, the case is that my lord, he has been caught red-handed. The person has been caught red-handed. This is not a case where he has been arrested on the basis of co-accused statement or other thing. He has been admittedly, he has been caught red-handed from the record. So my lord, my submission is that when a case wherein the person has been caught red-handed, this the Bihan Kumar, Pankaj Bansal, Praveen Purkashta will not apply. Why in matter? Because your lordship, if your lordship allows me, I would like to point out certain points. Why, my lord? Because here this whole proposition that giving grounds of arrest, my lord, came from the judgment, my lord, of which was passed by House of Lords in my lord Christie versus Linsky. If your lordship allow me, I will take this statement. Here, what is second, my lord, lordship knows that in England there is no written codified constitution. Law is developed as per parliament and the judgment passed by the honorable court, my lord. Here, my lord, the question arises when a person was arrested, he raised the issue whether he has not been submitted grounds of arrest. While discussing the same, this court, my lord, formed certain propositions, which were subsequently relied by our honorable Supreme Court in Madhu Lima case. I will come to that. My lord, may I kindly peruse page 72 of the judgment.
70.
572. 572. There are page marking. my lord?
Yes. Yes.
Below portion, my lord.
Hmm.
572 below portion.
Yes.
These citation and other which are referred by Lord D. Park seem to me establish the following proposition. These following propositions were observed. We are not first, my lord. I would like to point out first and third, my lord. In first proposition, my lord, if a policeman arrests without warrant on reasonable suspicion of felony or the other crime of a sort which does not require warrant, he must in ordinary circumstances inform the person arrested of the term ground of arrest. He is not entitled to give the person a reason to himself or to give reason which is not the true reason. In other words, the citizen is entitled to know the charges or the suspicion of what crime is seized. So this proposition says that he must know the grounds of his arrest. Now, my lord, kindly come to next page, the proposition number 3, my lord. Here, the Honorable House of Lords, my lord, they discuss the situation where person got red-handed. Here it has been said that, my lord, the requirement that a person arrested should be informed of the reason why he is seized naturally does not exist if the circumstances are such that he must know the general nature of the alleged offense for which he is detained. So by this proposition, this has been made clear that if a person knows that the circumstances for the reason for his arrest, meaning thereby if he is caught red-handed, my lord, this proposition, my lord, it is not bound to required to give grounds of reasons. My lord, these subsequently, my lord, this is in the House of Lords, my lord, subsequently in my lord Madhu Lima case, which is one of the first cases of Supreme Court knows that, my lord, and their Supreme Court relied those propositions. My lord, kindly peruse page 159. Sorry, page 161. Here, my lord, initially in Indian context, my lord, this issue was first raised. Here, the Honorable Court, my lord Supreme Court, discussed the Article 22(1), to my knowledge, for the first time, my lord, in this case, my lord. Here, what has happened that Madhu Lima was a political leader, he was arrested, my lord. He raised this issue. He was 89%, my lord. So here, while my lord deciding the issue whether grounds of arrest has to be given or not, my lord, this judgment of the House of Lords has been referred and engrossed. Here, my lord, kindly peruse page 161, my lord. Third paragraph, which starts from F. Below portion. Article 22(1) embodies a rule which has always been regarded as a vital and fundamental for safeguarding personal liberty in all legal systems where rule of law prevails. For example, the 6th Amendment of Constitution of United States of America contains similar provision, and so does Article 34 of Japanese Constitution.
In England, whenever an arrest is made without warrant, the arrested person has a right to be informed not only that he is being arrested, but also of the reason or grounds of arrest. The House of Lords in Christie and another versus Lissiski, which I have already referred to, went into the origin and development of this rule. So that rule was developed in that particular case, which I have already referred to. When is the origin and development of this rule? In the words of Viscount Simon, if a policeman who entertained a reasonable suspicion that X had committed a felony were at liberty to arrest him and march him off to a police station without giving any explanation of why he was doing this, the prima facie right of personal liberty would be gravely infringed. Viscount Simon laid down several propositions which were not meant to be exhaustive. For our purpose, we may refer to first and third, which I have already read. First, in the first proposition, it was said that grounds of arrest has to be given. In the third proposition, it was said that if he is caught red-handed, it is not necessary. Then, my lord, Lord Simons gave an illustration of the circumstances where the accused must know why he is being arrested. Under quote, my lord, there is no need to explain the reason of arrest if the arrested man is caught red-handed and the crime is patent to high heaven. So if he knew that he is doing illegal act, suppose that somebody is killing somebody, he is caught red-handed, cell police will wait to arrest him till giving ground of arrest, my lord. So in such circumstances, this case was discussed. Although this case is certainly different, but why I'm relying this, my lord, to show that Honorable Supreme Court also developed this rule from based on that particular judgment. Subsequently, my lord, here can be Peru space 163, my lord. Third paragraph, my lord. My lord, F. It is started from, my lord, it has not been contended on behalf of the state that circumstances were such that the arrested person must have known the general nature of the LS offense for which they had been arrested. By proposition number 3, Christie versus another so-and-so. Nor it has been suggested that the so-called notice which were issued on November so-and-so satisfies constitutional requirement. Madhu Limaye and others therefore entitled to be released on this ground alone. Here, he was released because there was no grounds of arrest shown, but it was observed here that state also didn't show that he knew the consequences of his action. So considering that aspect, he was subsequently released. This is Madhu Limaye. Subsequently, my lord, in judgment of my lord, Allahabad High Court, my lord. Here, my lord, what has happened, one person and perhaps one advocate assaulted the judicial officer, my lord. Subsequently, he was arrested, my lord. He had taken the ground that he was not supplied with grounds of arrest. Subsequently, it was challenged. Here, my lord, may kindly Peru space, my lord, para 5. My lord is taking Om Prakash Dwivedi.
So two you have given Om Prakash, same.
Oh,
order.
same, my lord.
Yes, in which para? 5.
Start from para 5. Yeah. The submission of the learned counsel for the applicant that if detention is violative of the provision contained in Article 22(1) Constitution or Section 50 of the Code of Criminal Procedure, the detention will be illegal and the applicant will be entitled to bail is quite correct. And it has been so laid down in the decision relied upon by him, not so the inference that in the present case, the reason for detention were not known or may not be deemed to be disclosed to the applicant within meaning of the aforesaid provision. In the matter of Madhu Limaye, so-and-so, Honorable Supreme Court referred to and reiterated the following observation of Viscount Simon, so-and-so. It has also been referred here. Same thing, I will not read, my lord. Then, observing that observation made in Madhu Limaye and this House of Lords judgment, this court held that para 6, my lord. It is apparent from this observation that what is important is that a person concerned must be fully aware of the reasons for his detention and not really as to how these reasons have come to his knowledge. As has been explained in the observation of Viscount Simon, there is no need to explain handed. There is some mistake, my lord, and the crime is patent. In other words, according to this observation, if a person is apprehended at the spot while committing the crime, he must be deemed to be in the know of the reasons for his detention, and failure of the concerned authorities to inform him of these reasons separately will not at all be material and will not adversely affect the legality of his detention. So if he's caught red-handed, it's not necessary. As per this judgment. In para 7, another judgment has been referred in para 7. In Mustaq Ahmed versus State of UP so-and-so, the applicant was caught red-handed by the complainant and others at the time of occurrence and was taken to the police station where the complainant lodged a report of the occurrence and handed over the applicant to the police. It was contended on behalf of the applicant that detention of the applicant was illegal and he was entitled to bail. The decision of Bimal Kishore so-and-so were cited before learned judge in the support of his submission. On the facts of the case, learned judge repelled the contention and held. In this case, the appellant was caught red-handed by the complainant and others at the time of occurrence and was taken to the police station where the complainant lodged the report of occurrence and handed over the applicant to the police. In these circumstances, it cannot be accepted that the applicant was not informed of the particulars of the offense for which he was arrested. Here also similar observation was made by the observation made by learned single judge Mustaq Ahmed so would appeal to be fully sustainable in view of the decision of this Honorable Supreme Court in the matter of Madhulimaya. Particularly, the observation endorsed and retreated by the apex court in indicated above. Therefore, with respect, I fully subscribe to the view taken by the learned single judge in Mustaq Ahmed so. Accordingly, it must be held that if the accused is apprehended at the spot while committing the crime, handed over to the police and detained, the detention cannot be challenged on the ground that provisions of Article 22 of Constitution or Section 50 of the Code of Criminal Procedure have not been complied with. As is obvious from this observation, Viscount Simon endorsed and retreated by the Honorable Supreme Court the requirement that a person arrested should be informed or the reason why he is seized does not exist if the circumstances are such that he must know the general nature of the LS offense for which he is detained. Quite obviously, the object behind of Article 22(1), this is important minor, Constitution of and Section 50 of the Code of Civil Procedure, which is now Section 47 of BNSS minor, is mentioned in the following observation of Supreme Court in Madhulimaya. That requirement of Clause 1 or Article 22 are meant to afford the earliest opportunity to the arrested person to remove any mistake, misapprehension, or misunderstanding in the minds of the arresting authority, and also to know exactly what the accusation against him is so that he can exercise the second right, namely consulting a legal practitioner of his choice and to be defended. When a person is apprehended while committing a crime and handed over to the public in the same transaction, it is quite reasonable to presume that he fully understands the reason of his arrest and detention so as to avail the right given to him under Article 22 of the Constitution. In such circumstances, therefore, it may not be considered to be imperative on the part of the arresting or detaining authority to disclose the reasons of the detention. If this is not done, the detention cannot be said to be illegal within the meaning of appropriate provision. So, Article 22, why it has been provided so that he can consult a legal, but he should know his reasons and he should consult a legal counsel. But when he commits a crime, which he knows that this is illegal, so he cannot exercise the right as per this judgment. In the special facts of the case, which are distinguishable from the fact of the other decision cited by the learned counsel for the applicant and noted above, it is not necessary to discuss the other decisions from the decision required. As indicated above, para 11 minor. In the present case, the applicant was apprehended at the spot at the time of commission of the crime, handed over to police. Even a layman would be understand the reason for his detention in these circumstances. The applicant is an advocate and as such person conversant with law. Therefore, it is reasonable to presume that in the circumstances that he must have fully known the reason of detention. According to submission of the learned counsel, for the applicant that provision of Article 22 Constitution or Section 50 of the Code of Criminal Procedure have been violated cannot be accepted. So, when the person is caught red-handed, as per this decision, is not required in my submission. Now coming to the question of my lord, because after this, my lord, there is actually I have not found any cases regarding this Article 22 and this thing, my lord. Our Honorable High Court dealt with a case in 1976 or 1976, I forgot, Ajit Sharma's case, my lord. But these points were not raised there. Subsequently, my lord, this Pankaj Bansal came. In Pankaj Bansal, the issue was different. Although this issue was also dealt with under PMLA Act. There also this issue to the effect whether what will happen if a person got red-handed, that was not dealt with. Subsequently, Prabir Purkasto came. There also this issue was not dealt. Then Bihan Kumar came. Bihan Kumar relied upon Pankaj Bansal and Praveen Purkasto, my lord, expanded the proposition. There also, my lord, this issue, but I am submitting, my lord, the issue of the situation where a person is caught red-handed was not dealt with. So your lordship is aware that if a point is not taken while passing a judgment, my lord, that a legal policy is not taken while passing a judgment, my lord, that judgment is in sub silentio regarding to that point. So that cannot be a precedent regarding this where a person is caught red-handed, applying the doctrine of sub silentio. So this Praveen Bansal, Praveen Purkasto, Bihan Kumar, or Pankaj Bansal, this case will not help the present petitioner because those issues were different. Those are general in nature. There it was not conceived nor argued nor observed by the Honorable Supreme Court, my lord, the issue of a person what red-handed man. So Supreme Court was silent regarding this issue. And applying the doctrine of substance silence, I have not getting any judgment to that effect. I lordship knows about that doctrine. So Supreme Court is silent to that effect, and to that effect, my lord, these judgments are not a precedent in my humble submission. And my lord, and another thing, here the person was arrested on, my lord, 14 to 2023, and that is prior to passing of Pankaj Bansal judgment. Because your lordship knows that these issues repeatedly came after Pankaj Bansal judgment, my lord. And my lord, Pankaj Bansal judgment, in my lord, in Ramkishore Arora versus Director of Enforcement, which was passed after Pankaj Bansal judgment, my lord. Here in para 23, my lord, I have only one copy. I'm sorry. Para 23, my lord. There it has been made clear that, my lord, Pankaj Bansal judgment will be applied prospectively, not retrospectively. Last page, madam, para 23. I have only one copy, so I am unable to read, my lord. Run to the, here it is said that it will come prospectively. Now, my lord, relying on the judgment, my lord, the Honorable Court of Punjab and Haryana, although it's a single judge, my lord, it's not binding upon your lordship, but it has persuasive value, my lord. Here, my lord, your value, lord. Keep. There are 10 more. Shall I read it, madam? Same Param Kishore Arora judgment was referred, madam. Para 10, I will not disturb your lordship. In Para 11, Provin Purkash is also discussed. And Para 12, Bihan Kumar was discussed. In Para 13, my lord, the observation, my lord. Thus, the proposition of law that emerges in the grounds of arrest must be supplied in writing to an accused, but the law as laid down in Pankaj Bansal is to supply it prospectively after 3/10/23, i.e., that date on which the judgment of Pankaj Bansal was pronounced. In the instant case, petitioner was arrested 23/2/22 months prior to 3/10/23. The date on which the judgment of Pankaj Bansal was pronounced. Therefore, he cannot get any benefit of the law as laid down in the aforementioned judgments. So here it has said that he cannot take the benefit of Pankaj Bansal Provin Purkash Bihan Kumar if he is arrested prior to the date on which Pankaj Bansal judgment was passed. Because it all originated from there. Similarly, my lord, similar thing was said in my lord, Honorable Division Bench judgment of my lord, Honorable Kerala High Court, my lord. In Para 20, I will not read it, my lord. In Para 20. Here, one thing has also been made it clear, my lord, that in Pankaj Bansal judgment, it was in respect to my lord's PMLA Act. Then in Provin Purkash law, it was expanded to my lord UAPA case, my lord, and subsequently in Bihan Kumar, it was generalized. So here, till Pankaj Bansal, there's no requirement to give grounds of arrest till the passing of judgment of Pankaj Bansal in a case relating to NDPS. Here also, the person was arrested in a UAPA case, my lord. The court held that since he was arrested prior to Pankaj Bansal's judgment, at that time the law was that there is no requirement to give him, my lord, grounds of arrest in UAPA case. So subsequently, that was added in Provin Purkash case. Similarly, here, since this person was arrested prior to Pankaj Bansal's case, my lord, at that time, it cannot be said that this is a violation, my lord, because that was the law at that time. This is my argument regarding grounds of arrest.
But just clarify one thing, Mr. Kaushik. The question is that in Provin Purkash, it is a thing, obviously, as you have submitted that it is definitely after Pankaj Bansal, and Pankaj Bansal was later on the hours. But the question is that in Bihan Kumar, there is on law observation is also there in regards to the cases where the case has already been charge sheeted. In that regard, what do you want to say? Charge sheet is you cannot justify a
Yes.
unlimited period when the charge sheet was there or not. So it is there that even if the case is charge sheeted in that case also, it may be applicable. The arrest may be, in that case, the arrest may be vitiated.
My lord, in that case, my lord, in Bihan Kumar, this Aurora case was not referred into. And this Aurora case was never overruled. This is still the law. And this is passed by the Honorable Supreme Court, Division Bench.
Aurora, you have submitted here?
Yes, I have submitted. My lord, in fact, day before yesterday, I should not submit, but it is for the lordship may not write it, but day before yesterday, these issues came up before Honorable Supreme Court. in a case, my lord, Mumbai hit and run case, my lord. There this issue has my lord, came up and Justice Gavai observed that, my lord, rightly questioned, my lord. What will happen if a person is caught red-handed with 100 kg of ganja? So this judgment has been, my lord, they have reserved the judgment, so I'm just quoting out of text, my lord. So hopefully that will come within 1 and 2 days. This is my argument regarding grounds of arrest. So far, my learned friend contention is that, my lord, length of detention. Here, my lord, out of 8 witnesses, out of 8 witnesses, already 4 has been examined. My lord, this ground, the prolonged incarceration, originated from the case of, to my knowledge, Mohammed Muslim. In Mohammed Muslim, the situation was different. In Ravi Prakash, the situation was different. In Mohammed Muslim, my lord, out of 20 or 30 witnesses, only 7 witnesses were examined in 5 years. Here, your lordship, because there are 2 things. Not only prolonged incarceration, my lord, there is delay in trial and there is no possibility of concluding the trial. In all the judgment, if a lawsuit goes, my lord, there are 2 points, my lord. There is delay in trial and there is no possibility of concluding the trial. This here, out of 8 witnesses, 4 already examined. So there is possibility of concluding the trial. Because Supreme Court has not fixed, in to my understanding, any time limit that this is the period, if you cross that, it will be termed as following incarceration. It will subjective, it will depend upon the cases to cases. Had it been a case where 30 witnesses are there, only 4 has been examined, I could have understood. Here only 4 witnesses are left to be examined. Meaning thereby it is a tracking of the crime. If it is released on this juncture, it will hamper the crime. This is my point, my lord. And regarding 37, your lordship knows, my lord. Here, my lord, I will rely, my lord, Mohit Agrawal case, your lordship knows that, my lord, and my lord, similar set of argument, my lord, I have made in this case, my lord, Bablu Pandey versus State of Assam of our High Court, my lord. Here, Mohit Agrawal, all these things are discussed, my lord. So my point is that, my lord, not only length of detention, your lordship have to see whether there is a possibility of concluding that crime. Because Mohammed Muslim, it is there in Ravi Prakash, it is also there. The Supreme Court has not fixed any cut-off date that if you cross this, it will be termed as prolonged incarceration. Yes, Supreme Court has passed release person up within 1 year, 6 months, 1 year, 4 months. But that is not the law. That is, they have not fixed the date. That has been passed considering that particular case, state of the case.
That is all.
So here the possibility of concluding the trial is there. So at this juncture, he should not be released. Before Roxy replies, I can submit the written argument also.
Better to submit your written argument because she may be in a position to
Yes.
not to reply because he had already discussed some of the judgment. I have said House of Lords judgments are also there. There are some observation regarding the person caught red-handed. So obviously, if you go by the general presumption also, the person who was red-handed with certain kind of amount of narcotics and all, so obviously person knows everything in fact. And there are some instances where he faced the trial, charges were already framed, so it cannot be held that he was not the grounds of arrest or reasons for arrest to be behind the bar is not known to him. So he will file a written objection. You also file see to it, or if you want any for further preparation, make us submission. Yes.
And one thing I let me make it clear, I am not challenging the Bihan or Prabi Gupesto or my lord Pankaj Bansal. Those are law. There was a settled law, my lord. My contention is that, my lord, those while passing those laws, my lord, they have skipped this point, my lord. What will happen if a person got red-handed? And to that effect, my lord, it is silence.
Yes.
May I, Lordship? May I, Lordship? I may take another date or so, but for that, I may be allowed to say 2 lines upon the objection given by Learned PP, sir, Lordship. Lordship, this is an NDPS case. Obviously, the stringent provision under section 37 attracts against the accused petitioner. The stringent provision which says that the honourable court has to be satisfied to the And the public prosecutor has to be given a reason that the accused is not guilty of that offense.
No, obviously, this is
that
the
obviously
37
comes.
only,
Yes.
37, yes.
Yes, but in Bihan Kumar Lordship, para 30, para 30 it has discussed in page number 8. I may be allowed to submit the citation.
I have parasitic, you just read
Yeah,
from there.
Lordship. In this regard, we may note that Article 22(1) of the Constitution provides inter alia that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. This being the fundamental right guaranteed to the arrested person. The mode of conveying information to the grounds of arrest must necessarily be meaningful so as to serve the intended purpose. It may be noted that Section 45 PMLA enables the person arrested under Section 19 whereas to seek release on bail, but it postulates that unless the twin condition prescribed thereunder are satisfied, such a person would not be entitled to grant of bail. The twin conditions set out in the provision are that firstly, the court must be satisfied after giving an opportunity to the public prosecutor to oppose the application for release, but there are reasonable grounds to believe that the arrested person is not guilty of the offense, and secondly, that he is not likely to commit any offense while on bail. To meet this requirement, it would be essential for the arrested person to be aware of the grounds on which the authorized officer arresting him, her under Section 19 on the basis of the offense's reasons to believe that he, she is guilty of an offense punishable under the 2002 Act. It is only if the arrested person has knowledge of these facts that he, she would be in a position to plead or prove before the special court that there are grounds to believe that he, she is not guilty of such offense so as to avail the relief of bail. Therefore, communication to the grounds of arrest as mandated under Article 22(1) of the Constitution and Section 19 of the PMLA is meant to serve this higher purpose and must be given due importance. It has been discussed. There may be 37. He may be guilty of the offense. There is a presumption, obviously, as
That's what I'm saying.
Yes.
37 is there, in spite of rigor of 37.
Yes.
We are applying this thing because this are the violation of those articles
Yes. Yes.
of Constitution. That is the issue and why the persons and some of the judgment or order has already been passed. But Mr. Kaushik raised the issue that if a person is caught red-handed, suppose a person is murdering someone,
Yes.
and in that spot only the police arrested. So obviously question of giving him the grounds of arrest may not be there.
Yes.
Similarly, in the case of NDPS also, the grounds of arrest may not be necessary also if the person required caught red-handed. And Mr. Kaushik is saying that those grounds where the accused or the person is caught red-handed, those issues were not discussed in those Prabir Purkaste and Bihan Kumar. That is his issue. So that's why I'm giving you some time. Take preparation because you have already heard and he is going to submit the written statement, written argument also. Keep preparing and submit us accordingly. Let it be after next week, it may be fixed. When you will be able to furnish this. Otherwise, we have noted down everything. Yes.
One more submission, Lordship. Maybe he is not being informed about the grounds of arrest and he is aware of the crime that he has committed. Lordship, there in the Bihan Kumar citation, Section 50A of the CRPC has been discussed.
Definitely discussed. Yes, we are not denying it. It is discussed.
discussed.
It is discussed in detail. Even it is discussed that even in case of the charged one, the person, if is not provided with the grounds of arrest, and in that case also the arrest will be illegal or it will be vitiated, the trial. But the question is that those issues were as per the Kaushik. I have not gone through the entire case, the judgments or the citation which has been provided to me. But the question is that was the issue. He raised this issue. So that's why I'm just giving you some time. He is going to submit the written argument, prepare the written argument as per you. Even if there is anything, suppose now he is saying that the Pankaj Banchal's case was of 23 to 2020. Prior to that issues was not there, and it was the effect was the prospective, not the so that was the reason why he is submitting. So just why I'm telling you, for 4 or 5 days or 1 week will not matter such. So let it be prepared for some time. Otherwise, Bihan Kumar Purkaste is very much clear into that effect. Why the arrest of grounds of arrest is necessary or why it should be provided. These are already discussed. And even if, that's why we are giving the bail in some cases, even if the case is charged sheeted also, or in stage of evidence also. So, but the question raised by Mr. Kaushik, that definitely is a question of thing. We have to issue on the all the cases wherein the grounds of arrest were considered, may not be considered at this stage, or we may reach the other best thing. So that's why I'm giving you time, in fact. Those grounds may not be considered. Or may be considered if the case position is otherwise, because case depend upon the case to case, the matters depend upon the case to case. In your case, admittedly, grounds of arrest or the notices, the grounds of arrest were not mentioned. It is admitted, right? I will not deny it. Okay. So when you can file your thing?
Any date, madam. Rules like
Not tomorrow. Tomorrow I have lots many.
next week, any day. Subject to my friends.
Day after tomorrow, maybe.
Day after
Monday,
tomorrow, we don't have any date. Day after tomorrow.
Monday or
Monday can
Tuesday?
be. Monday or Tuesday can be.
Tuesday,
okay.
Tuesday.
Tuesday, you will provide it with the copy and make preparation and submit all this.
I'll provide hard.
No, provide copy, you provided the copy, and if you want to submit on the day itself on Monday or Tuesday, that will be hard, or otherwise maybe fixed for other day for your preparation. So we are fixing on
No, Wednesday, next Wednesday.
Wednesday.
Next Wednesday.
Wednesday fix. Wednesday will be 3030. Please for matter is part her full Twitter. No, not legal, not necessary, not necessary. Both 9 and 10? Oh, both 9 and 10. If you do case record, so you get a file. You will have to case record. No. It case
My lord, I will also mail a soft copy, if your lordship permit me, to the court master. The written argument, it will be helpful for your lordship also.
Court master or private secretary? Or court master also you can read. 9 and 10 people only. 30, no? And I just wanted to tell you one thing. The SD Mr. Kaushik has submitted that there should be parity in the order passed in every cases. That till now we were observing that the grounds of arrest are the violative of Article 22(1). So that's what giving. So if there is any cases in that manner regarding only grounds of arrest, matters may be taken up after this thing, because same observation may be there, and there should not be any variation in the observation of this code. Maybe case may be different, but as you have mainly states on the caught red-handed matters and NDPS matters, most of the matters we have seen that the caught red-handed, and there are some matters where on the basis of some the co-accused statement, those will be arrested.
I think in today's court number 24, my lord, perhaps that may be, order may be delivered tomorrow, my lord. 24.
Okay. Court number 24.
24.
IA 56, your lordship will kindly take up IA. There are 2-3 IA. One is IA 56 AP of 2025.
Yes.
This IA we have filed basically under 2 provisions of law. One, that is Order 6, Rule 16, whereby we are paying that some of the, in fact, the 2 basic allegations of corrupt practice of undue influence and booth capturing are mentioned in paragraph 12 and 13. So practically all the paragraphs we are saying that do not disclose any cause of action, and therefore we pray under Order 6 Rule 16 to strike out those paragraphs. And then we have also invoked Order 7 Rule 11 of the Code of Civil Procedure on the ground that after striking out those paragraphs, nothing will remain in the election petition and no cause of action will survive. Therefore, the election
And then
petition
in that
itself will be
case, both the
rejected.
prayers can be heard together, in fact.
Together, madam,
One is for striking of prayer number 16 and 17,
is 12 and 13, madam.
12 and 13.
12, and there are subparagraphs 12.1, 12.2, 12.3 are there. But then basically paragraph 12 with all subparagraphs and paragraph 13 with all subparagraphs. First one is in respect of undue influence and second one is in respect of booth capturing.
So, Mr. Pada, are you have filed your objection already?
Yes, Lordship. In both
Your objection is there in
They are filed.
the IS we have filed, but Lordship,
and it is
if the
received.
other side is ready, then the matter may be taken as part hard today, my lord, because today Mr. A. Tatak was supposed to appear and he's unwell and could not come.
I'll not be able to complete.
Our
All
part
right.
may be heard next time, my lord, and if the other side is ready, then their part may be heard today.
Yeah, it's all right, madam.
So
Let me start.
who is appearing for the
My learned friend is saying, he's not very clearly
Very
audible.
clear, yes,
What
yes.
my learned friend is saying is matter may be heard, but then at last it may be kept parter for his reply to some other date. It's no difficulty.
So now cases dealt by some other
My,
advocates?
my learned friend, Mr. KP Pathak is.
Oh, acha.
Yeah.
Okay.
So for reply today, possibly today, I won't be able to complete because even otherwise matter will go to the next date.
It will give objection. Okay.
Let me see if I can complete today.
Just a second.
IA 56, madam.
Yes, I 56. No, I'm searching for their objection.
Yes, they have filed their objection. We have been served with a copy of their objection. Madam, running page 25 possibly tagged with the IA.
Yes,
itself.
yes.
So they have filed their objection, madam.
So, Mr. Pada, we are going to hear Mr. Mojumdar.
Yes, Lord.
Matter will remain as a partner, and rest your part will be heard afterward.
Yes,
Will
ma'am.
be okay then. Okay. But Mr. Mojumdar, your time will take 1 hour. Will it can be completed within
I'll
1
see, well, if I can complete in 1 hour, it is all right. If as for some reason, if I have to take some more time because some case was also I am relying, then your lordship will fix another date, madam. Let me argue for one.
Okay.
Now, this is a case where lordship will find at page 8, page 126 at document 8. The present applicant who is implicated as the respondent,
Election.
number 1. Lordship may kindly take up the election petition first.
Yes. Page number 126.
126. That is the final result sheet prepared in Form 20 of the Conduct of Election Rules 1961.
Yes.
Now, Form 20 at page 126 is the result sheet, final result sheet, my lord. There were only 2 candidates in the fray, my lord. The first column is for the respondent number 1, the present applicant before your lordship, who has been declared elected from number 2. From this is called Nari Koyo ST Assembly Constituency, 36 Nari Koyu ST Assembly Constituency. Well, I'm showing this this final result sheet for the purpose of pointing out that the applicant before your lordship who has been declared elected has secured 4,545 votes. Lordship will notice at the end, my lord, total votes have been counted. And total votes polled are 4,545, whereas given upon the election petitioner, who is the respondent in the present IA, has secured 2,896 votes.
Your respondent is in serial number?
It's first, my lord, first row. First column rather. Tojir Kadu, he has secured 4,545 votes. And the gagging upon the election petitioner has secured 2,896 votes. So there is a difference of 1,649 votes. This I am showing in the very beginning because there is a purpose, my lord. it is not a case where the return candidate has won the election by a small margin of 5, 10, 20, 30 votes. And as alleged in the election petition, to which I'll come at a later point of time, my lord, that there were impersonation in respect of some of the voters. In place of the real voter, someone else has come. These allegations are there. Someone else has come and cast their vote. So there was impersonation. Now, if there are allegations of impersonation, my lord, then I'll show from the act that this will fall in the category of grounds mentioned in section 100(1) D(4), which requires the election petitioner to not only show that there was impersonation, but also to show that some impersonation has resulted in. Well, I'll come to the provisions. Your lordship need not worry for that. I'm just indicating so that your lordship gets the contour of what I am going to add. So if there is an allegation of impersonation, the burden of the election petitioner will be not only to show that there was impersonation and the votes in respect of some of the actual voters were in fact cast by some other person who is not the real voter, either by force or by some other way. In those events, my lord, the burden will be, in addition to that, they will also have to show that how it has materially affected the result of election of the return candidate. The reason is, my lord, there is a reason. Reason is, if 5 votes are cast by way of impersonation, and those 5 votes are to be deducted in the trial, deducted from the votes secured by the return candidate, then if there is a small margin of say 4 votes, then the result will be different. In that case, my lord, I cannot pray, or rather I cannot argue that this particular allegation does not carry any cause of action, because at this stage your lordship will have to accept all the averments made in the election petition to be correct. In the case of Rajiv Gandhi versus Azhar Hussain, my lord, the Honorable Supreme Court has laid down that at this stage your lordship will consider all the averments made in the election petition to be correct. And if those are taken to be correct and without the requirement of filing written statement, or even if the written statement is not filed and there is no contest and the allegations are taken to be correct, then a direct verdict can be given in favor of the election petitioner. In that case, there is no question of striking out or rejecting the election petition under Order 7, Rule 11. This is what I am trying to indicate. And that is why I am showing that this is a case where the present respondent, who is the return candidate, has been democratically elected in the election and by a margin of 1,649 votes. And I'll show now from the averments made in the election petition that all the averments made in the election petition taken as a whole will not disclose any cause of action, much less about the allegation of corrupt practice of undue influence and booth capturing. And that is why we are praying that those paragraphs where they have alleged about booth capturing and undue influence should be struck out. And after those paragraphs are struck out, nothing will survive in the election petition. Then by invocation of Order 7, Rule 11, we are praying that the election petition should be rejected and it should be nipped in the bud. On the Supreme Court says that in such cases, it should be nipped in the bud instead of allowing the sword to hover over the head of the return candidate. Now, my lord, after showing this, I will take your lordship to the relevant paragraph. Paragraph 5, I'm sorry, paragraph 4. In paragraph 4, the petitioner has given, of course, from the notification, the schedule of the various dates on which various steps for the holding of election will take place. Page 10, which is a part of paragraph 4 of the election petition, Lordship will find page 10, madam, of the election petition.
Yes.
The 27th of March 2024 was the date for making nomination. And 28th of March 2024 was the date for scrutiny of nomination papers. 30th March was the last date for withdrawal of nomination paper. Then 19th April was the date for poll. And 2nd of June 2024 as the date for which the election should be completed. In fact, my lord, this is the date for counting, 2nd of June 2024. Then, my lord, Lordship will find in paragraph 6 at page 12. Because in paragraph 5, they have mentioned that both the parties have filed their nomination paper. So far as the present applicant is concerned, he was nominated by the BJP, by Bharatiya Janata Party, and the election petitioner was nominated by Arunachal Democratic Party. Para 6 at page 12, my lord, what will see, this has been mentioned. Who was nominated by which party? Then at para 9 at page 14, the result of the election was declared on 2nd of June 2024. And the final result sheet was prepared in Form 20, which I have just now shown to your lordship. Then paragraph 10 onward, they have started the allegations. That the election of the returned candidate from LA number, Legislative Assembly constituency number 36, Nari Koyu ST, is liable to be declared void on the ground of corrupt practices committed by the returned candidate and his election agents, including his supporters and workers, with the consent and connivance of the returned candidate, and the material facts and particulars thereof are pleaded hereinafter. That the petitioner states that there are only 2 candidates in the fray in the last election from LA number 36 Nari Koyu ST Assembly constituency, and but for the votes obtained by the returned candidate by means of corrupt practice hereinafter mentioned, the petitioner would have obtained a majority of valid votes. That in view of the material facts read with particulars thereof, the election of the returned candidate is liable to be declared void, with a further declaration from this honorable court that election petitioner as duly elected from LA number 36 Nari Koyu ST Assembly constituency. So his prayer is that my election should be set aside and the petitioner should be declared to be elected from the same constituency. Now the real allegations start from paragraph 12, where they have given a heading. Paragraph 12 says, material facts and particulars of corrupt practice of undue influence committed by returned candidate. Well, I go to the definition in section 123, subsection 2 of the Representation of People Act at some later point of time. I'm reading the allegations first. 12.1, that one of the proposers of election petitioner, Sri Ninia Angu, were attacked by party workers and supporters of respondent, hereafter referred to as the returned candidate, during the time of filing of nomination paper for election to Legislative Assembly number 36, Nari Koyu ST Assembly constituency at about 1:30 p.m. on 27/3/2024, thereby attempting to prevent the election petitioner from filing his nomination paper and interfered with the right of the election petitioner to stand as a candidate from the LA number 36 Nari Koyu ST Assembly constituency. Further, Sri Ninia Angu was assaulted near the police barricade placed before the office of Deputy Commissioner Likawali, Lower Siang District, Arunachal Pradesh, on the date of filing of nomination, that is at about 1:30 p.m. on 27/3/2024. During such assault, Sri Ninia Angu's clothes were torn apart and his sunglasses were also broken by the supporters of the returned candidate. The party workers and supporters of the returned candidate, few of whom could be identified by the election petitioner and his supporters are Sri Jumli Kaki, then his address is given, son of Swen of Lower Siang district. Then Sri Kium Kaki, again son of Swen, address is given. Then Sri Goni Kae, another person. So these are the persons. Such party workers not only manhandled and assaulted the proposer of the election petitioner, but also verbally abused and tried to assault them with sharp weapons in presence of security people standing near the aforesaid polling barricade, tacitly supporting such supporters of the returned candidate as members of the ruling dispensation. The petitioner craves leave of this honorable court to submit the names of other attackers, abusers, at the time of trial of the election petition. Now, this is first paragraph. Second paragraph, there is paragraph 12, Roman 2. That the returned candidate through his party workers and supporters threatened the election petitioner and his supporters with the dire consequences if they campaign in LA number so. As such, the election petitioner had to seek intervention from the returning officer, assembly constituency, to provide adequate security for election campaign. However, the same was denied by the state authority. As a result, the election petitioner was prevented from election campaign in LA number so, particularly Serene village, by the supporters, workers of returned candidate, which adversely affected the prospect of the election petitioner to win the election, and thereby the returned candidate, his agents and supporters committed corrupt practice of undue influence. Lordship will kindly note, this is how they are trying to make out a case of undue influence committed by the returned candidate. The party workers and supporters of the election petitioner who were threatened with dire consequences on 28/3/2024 are Ninia Angu, Kartom Mayong, and Daniel Padung. Then paragraph 3. That the election petitioner, one of his proposer, Sri Ninia Angu, and supporter Sri Kartom Mayong, were manhandled and restrained from entering the office of the returning officer, situated at office of the Deputy Commissioner, Likavali, Lower Siang District, Arunachal Pradesh, at the time of scrutiny of the nomination paper for election to LA number so by the supporters of the returned candidate, few of whom are Sri Ili Koyu, then address is given, then Sri Minge Kadu, address is given, then Sri Dakge Riba with his address, and lastly Sri Chi Kadu, and then his son of etc. address is given. Thereby, after that, thereby the returned candidate interfered with the election process, including the free exercise of electoral rights of the voters of the constituency, which adversely affected the prospect of the election petitioner to win the election, and thereby the returned candidate, his agents and supporters committed corrupt practice of undue influence. The aforesaid incidents were captured by video recording in the mobile, which with the leave of the court, the election petitioner would submit in the pen drive at the stage of production of documents during the course of trial. Now, paragraph 12, Roman 4. That the petitioner, along with his supporters and workers, namely Sri Bomli Kae, then after 2 lines, Monjit Goyari, Itanagar address is given, and his 2 personal security officers, namely Tumka Doyum and Sri Katen Sitek, who were returning back on 30th of March 2024 at about 9:30 p.m. after visiting Sri Rekar Koyu, election agent of the election petitioner, were attacked by supporters and workers of the returned candidate at around 9:30 p.m. on 30th of March 2024 after intercepting their convoy carrying supporters. The mob of around 40 to 50 persons that had blocked the road and attacked the convoy of election petitioner were led by Sri Gomi Doye, son of Swenso, Sri Mike Kadu, son of Swenso, Sri Iri Doye, son of Sri Swenso, Sri Kirdo Doye, son of Sri Swenso, then Sri Toi Doye, son of Sri Swenso, and Sri Bago Doye, son of Sri Swenso, Further, the mob led by the said persons had pelted stones towards the convoy of the election petitioner, thereby causing damage to the vehicles and inflicted injuries to some of the supporters who had accompanied the election petitioner. It was only after the intervention of local police the mob could be dispersed. This kind of incidents caused fear in the minds of the general electors that if they do not vote for the returned candidate, they will face dire consequences in the post-election period. Few of such voters who got scared to vote the election petitioner and vote for the election petitioner and ultimately voted for the returned candidate had later informed the same to the election petitioner. Being aggrieved by the said incident, the son of petitioner C. Gepeng Apang lodged an FIR on 31st March 2024 before the officer in charge polling station Nari. However, no action had been initiated by the state authority. As such, illegal acts of supporters and workers of returned candidate went undeterred, which ultimately led to a victory, materially affecting the result of election of the returned candidate with illegal and corrupt practice of undue influence on the voters of LA number so-and-so. The aforesaid incidents were captured by video recording in the mobile, which will be, with the leave of the court, the election petitioner would submit in the pen drive at the stage of production of documents during the course of trial. Now, last paragraph, possibly paragraph 12, Roman 5, that the returning officer of the state assembly constituency in connivance of the returned candidate and his agents and supporters deliberately failed to install CCTV camera at Loglu polling station, Tamiripo polling station, Sipu polling station, and Kote polling station, which led to the commission of violence against coupled with undue influence on the supporters of election petitioner, thereby ultimately leading to interference with the free exercise of electors' right. Few of the supporters of the returned candidate, whom could be identified, are Sri Nina Kadu, Vicky Padung, Sri Mike Kadu of Poteville. Such violence took place with the connivance, support, and knowledge of returned candidate. Now, before I go to the next allegation of booth capturing, my lord, Dr. will kindly permit me to point out certain things, my lord. In paragraph 12.2 at page 18, they have mentioned about the threat being given to the election petitioner and his supporters of dire consequences, etc. And then they said they filed a representation alleging all these things. Now, this representation of 28th of March 2024, they have annexed as a document number 9, which your lordship will find at page 129. 128. One is a very small complaint, 4-5 lines. It's a letter by Gegong Apang himself to the returning officer. Request for providing police escort for self-protection. With respect, it is to inform you that I am contesting as a candidate in the upcoming Assembly election 2024 from so-and-so, and would like to request you to provide me police escort for campaigning purpose, as I was threatened by the opposition party worker and they would not allow me to campaign in their respective region and dared me to campaign in their region by stating that they will hunt us however possible. This is for your kind information and necessary action, please. Thanking you in anticipation. So, lordship, in paragraph 12, Roman 2, your lordship has seen how the allegations have been amplified. And after the end of the allegations, when they say that we have submitted a representation to the returning officer's representation, his representation to the returning officer does not contain any such allegations. if something had really happened as is mentioned in paragraph Roman 2, then the same would have found place in the representation itself. Now, representation is silent about all these allegations. I'm just indicating it that these are amplifications. Otherwise, even if we accept, I'll show my, even if we accept these allegations made in paragraph 2, will not be sufficient to make out a cause of action. I'll come to that matter. On top of that manner, so far as the allegation in paragraph Roman 12:4 is concerned, at page 23, they have said that after the incident, they have submitted a FIR. FIR is of 31st of March 2024, which your lordship will find at page 130. That could be recently. 130, my lord, and its type copy is available at 133. The requirement under the law is that precise statement of material facts, and if there is a allegation of poor practice, then particulars will have to be given in the elective petition. But that doesn't mean that if something is not there, and they will incorporate in the petition and then try to make out a case. This is what is happening here. Now, this FIR lodged on 31st of March 2024, type copy is given at page 133, madam. I'm just reading the type copy, not much, just 2 paragraphs. In your jurisdiction, yesterday night at 9 p.m., my father, Sri Yagung Apang, also the candidate for 36 Nari Koi constituency, was meeting some old friends in Serene village, Serene CO circle. After meeting his parents, Mr. Yagung Apang, along with his well-wisher's son, Sri Larken Doye, who was guiding him through unknown roads of Serene. Mr. Yagung was accompanied by his 2 PSO, Mr. So-and-so and so-and-so, driver Bipul Rava, all were in one car, the third in the convoy. First car was Mr. Larken Doye's, second car was Mr. Bomli Koye, third car was Mr. Yagung Apang, and fourth car, Mr. Manjit Gayari, PA. At around 9:30 p.m., a person blocked the road near ZPM, Mr. Marbom Doye's house by hitting on the bonnet. Then within minutes of mob of 40 to 50 persons gathered around 4 cars, asking and shouting Bahar Niklo. In Hindi, they have used Bahar Niklo. Yes. Get out of the car right now. At that moment, Mr. Bomli locked his car. With him was Mr. Lee Koyo from ADP party. Then they started hitting the bonnet of Mr. Bomli Kaye, punched the window shield of Mr. Bomli, also hit the window by grabbing stones. Marks are still visible on the cars, hopefully will be compensated. Meanwhile, at this sometime, Mr. Bipul Rabha was recording video. He is the driver of Mr. Yagung Apang. Couple of boys tried hitting the car of Mr. Bomli from backside, but could not toss or turn the vehicle. At the same time, the mob started hitting Mr. G. Apang car, thereby intimidating. Then the PSO, Mr. Katan Sitek, came out to perform his duty to protect Mr. Yagung Apang. Then some couple of boys manhandled him, which is captured in the video. He was rounded up by the men and some hold his hand to make him move less, and other tried taking his pistol, service pistol. Then the PSO came inside the car to protect himself. Also, the other PSO, Mr. Tumka Doyom, was being verbally abused and intimidated. By this time, police came and took another 10-15 minutes to calm the mob. The details of person involved were identified and are being mentioned down below. Identified persons according to video. Now they have given the names. It is a humble request to you to please see the another and register FIR and accept. Now, these are the allegations. What we will find, these allegations do not have any relation with the election. They are trying to make out a case of threat, etc., that one should not campaign, etc. But this doesn't say that they have gone anywhere for campaigning. the allegation itself, I'm just showing that the correctness of the allegations made in the election petition based on the FIR. FIR says they went somewhere to visit somebody, and while coming back, some miscreants attacked them, assuming that allegations in the FIR are correct. Even then, my lord, this is an incident which has got no connection with the election, much less of any undue influence of voters. Now, my lordship will see what is there in paragraph 13 of booth capturing. That your lordship will find at page 24 of the petition manual. Huh?
Yes,
Page 24, manual, para 13.
yes.
Material facts and particulars of power practice of booth capturing committed by the returned candidate. Para 13.1. That apprehending booth capturing of various polling stations in 36 so-and-so constituency, the election petitioner had made a representation to the district election officer, Likabari, Lower Siang district, to provide adequate deployment of security in all polling stations by representation dated 15/4/2024. However, the authority concerned failed to consider the same. Further, the concerned authority had even failed to install CCTV cameras in all the polling stations. As such, taking advantage of the absence of video recording, the polling agent, namely Sri Kumar Padung, along with other supporters of the returned candidate, along with few others of the returned candidate in connivance with and with the support of the returned candidate. Because if these words are very important, in connivance with and with the support of the returned candidate. I will show, my lord, from the act that the allegation of connivance and allegation of support, if it is correct today, because the lordship will have to accept all the allegations to be correct. These averments, these allegations do not come within the meaning of, my lord, proper practice of booth capturing. Now, taking advantage of the absence of video recording, the polling agent, namely Sri Kumar Padung, along with other supporters of returned candidate, and along with few other such supporters of returned candidate, in connivance with and with the support of returned candidate on the date of polling, that is 19/4/2024, captured the 21 Pote polling station at Pote village and prevented the voters in general, including the confirmed supporters of election petitioner, from casting their votes in favor of the election petitioner. Now, this is an allegation on which they are trying to say that booth was captured. One of such supporters of election petitioner, Sri Ananto Goswami, and who is a voter of LA number so-and-so, and who was to vote in 21 Pote polling station along with his family members, were intimidated by supporters of returned candidate. One, again, the supporters of returned candidate, one of whom Sri Nina Kadu. Sri Nina Kadu, along with others in support of the returned candidate, in connivance with presiding officer of the polling station, indeed cast votes impersonating. Again, there is an allegation of impersonation. This is what I was trying to indicate in the beginning, my lord. Impersonating the actual voters, namely Ananto Goswami, serial number 281, Miss Anima Goswami, serial number 280, and Miss Moromi Goswami, serial number 279. It is also pertinent to mention here that the vote of the absentee, that is Srimati Yapa Kadu, serial number 118, was voted by Srimati Yaken Muji of Pote village in favor of the returned candidate. Next allegation is paragraph 13.2. That it is also opposite to state here that after capturing the 21 Pote polling station, the supporters of the returned candidate had also cast votes of absentee and Sri Mangal Singh Yadav, serial number so-and-so, and his family, and also those of the absentees who had cast their votes through postal ballot. The concept of postal ballot is totally different. Postal ballot system is that they will make an application,
Yes.
and there are certain specified persons mentioned under section 20 and 60 of the Representation of People Act who are entitled to vote through postal ballot. They will make an application, then their form 13 will be sent to them, and they will have to cast their vote there, and they'll send it to by post to the returning officer. Returning officer will keep it with him, and only on the day of counting it will be opened. This is the system of postal ballot. Now the allegation is such that somebody came and cast votes of who were supposed to cast their votes through postal ballot. It cannot be an allegation. For that particular person, there is no question of casting any vote. He will be not allowed, because in the election, my lord, your lordship is aware, a marked copy of electoral roll is maintained at the booth. It is called marked copy of electoral roll. There it will be marked which votes are to be cast through postal ballot. For that person, nobody else will be allowed to cast a vote. Even if he casts a vote, that will not be counted. So that cannot be an allegation of corrupt practice, of booth capturing, and that too of impersonation. This allegation itself is not within the framework of the law. Then Roman 3 of para 13. After capturing 21 Pote polling station on the polling date, in connivance with presiding officer, in respect of the said polling booth station, the supporters of return candidate, including Sri Nina Kadu, with the active support of return candidate, even cast the vote of deceased persons. Again, this is impersonation allegation, my lord. Late Tajum Kadu of Pote village, who expired on 23rd of September 2022, and whose name is reflected in the electoral roll number 117 of the state polling station, in favor of the return candidate. The stiff opposition from the polling agents of the election petitioner in this kind of incidents of booth capturing by the supporters of the return candidate was of no avail, since the booth capturing was done with the knowledge and connivance of the presiding officer. This is the allegation. I'll make my submissions later, my lord. I'm just indicating what are their allegations. Para 13, Roman 4 at page 28 are the next allegation, my lord. Possibly that is the last. That it is also to state that various other polling stations, namely 14 Tabi Ripo, 11 Loglu, and 7 Sipu, were also captured by the supporters of the return candidate. As such, various representations were made to the competent authorities, bringing the notice of the same and prayed for fresh poll in the said polling stations. Representations are mentioned of 19/4/23, 20th April, 20th April, 21st April, 23rd April, and 23rd April. Further, the election agent of the election petitioner had also lodged a complaint dated 19/4/2024 against the polling officers of polling station in Kaki and Pote village before the officer in charge, Nari police station, Lower Siang district. And also to substantiate the booth capturing incident by the return candidate and his supporters, the election petitioner had provided documentary evidences to the chief electoral officer, Lower Siang district, Arunachal Pradesh, by letter dated 8/5/2024. However, the authorities concerned had utterly failed to address the grievances set forth in the above mentioned representation or complaint, despite there being prima facie case of booth capturing by the return candidate, his man, agents, and supporters. As a result, the said incident of booth capturing had materially affected the result of the election of number so constituency. So these are the allegations. And and in the petition, they have elaborated the two types of allegations of corrupt practice, of undue influence of corrupt practice. And from there, I have prepared a short synopsis of what are the actual allegations, so as to deal with them, my lord, in terms of the requirement of, my lord, section 100 and other provisions of the Act. My lord, in short, here you will find paragraph 3. As regards the allegation of corrupt practice of undue influence, the allegations are as under. 12-1. In the 12-1, what they have done is, see, Angu, one of the proposers of election petitioner was attacked by the party workers and supporters of respondent number 1 at the time of filing the nomination paper for LA so-and-so constituency at 1:30 PM on 27/3/2024, which is the date of submission of nomination paper, and thereby attempted to prevent the petitioner from filing his nomination paper. See, Ninia Angu was assaulted near police barricade at the aforesaid time and date, and his clothes were torn and sunglasses broken by the supporters of respondent number 1. The party workers and supporters of respondent number 1 manhandled and assaulted the proposer of election petitioner are so-and-so, 3 persons. Now I am dealing with this first paragraph of paragraph 12-1. Lordship has seen what is the allegation. Allegation is on the date of submission of nomination paper at around 1:30 PM, election petitioner's proposer was, there was an attempt to prevent him from filing the nomination paper, but ultimately he has filed the nomination paper. Nomination paper was filed. It's not the allegation that because of this, a nomination paper could not be filed. And I will show my note from page 54. Lordship will kindly see how baseless allegation was brought at page 54. Page 54. And it is the last page of the nomination paper where the time of submission of nomination paper is mentioned by the returning officer. And the last part, page 54, the last part is at the bottom is part 4, which is to be filled up by the returning officer. It's mentioned there. Returning officer has filled up this part, saying that this nomination was delivered to me at my office at 12:42 hour. And their allegation is at 1:30 PM, while he was going to submit the nomination paper, his election agent, he was prevented. I am again, my lord, submitting, my lord, at the cost of repetition, that I am not saying that your lordship will examine the correctness of the allegation. Assuming that this allegation is correct, your lordship will proceed today. My lord, the allegation itself from their own document says that it is not correct. What will be the effect of this? Your lordship will consider. But this is also not very important, my lord. What is important is, if actually, my lordship will kindly take up this Representation of People Act. Representation of People. If your lordship is holding this book, possibly it will be page 97.
I think so.
Yeah, page 97, lordship may find. There's a part 7, chapter 1, for our practices.
Yes.
Now, for our practice has been defined. I mean, it's mentioned in section 123. For our practices, the following shall be deemed to be for our practices for the purposes of this act. Now, first one is bribery. We need not bother ourselves, my lord. Subsection 2 is undue influence.
Yes.
Now, undue influence, that is to say, it's defined here, my lord. The undue influence, that is to say, any direct or indirect interference or attempt to interfere on the part of the candidate, that is the applicant before lordship, or his agent, or of any other person with the consent of the candidate or his election agent, with the free exercise of any electoral right, provided that without prejudice to the generality of the provisions of this clause, any such person as is referred to herein who threatens any candidate or any elector or any person in whom a candidate or an elector interested with injury of any kind, including social ostracism and excommunication or expulsion from any caste or community, or induces or attempts to induce a candidate or an elector to believe that he or it induces or attempts to induce a candidate or an elector to believe that he or any person in whom he is interested will become or will be rendered an object of divine displeasure or spiritual censure, shall be deemed to interfere with the free exercise of the electoral right of such candidate or elector within the meaning of this clause. A declaration of public policy or a promise of publication or the more exercise of a legal right without intent to interfere with the electoral right shall not be deemed to be interference within the meaning of this clause. So, Lordship has seen undue influence has been defined here. Now, they are trying to say that a person was going to submit his nomination paper and he was prevented by some person. Now, the requirement of law is, first of all, you have to show that you have to come within the definition of undue influence as contemplated under section 123, subsection 2. It says any direct or indirect interference or attempt to interfere on the part of the candidate. So admittedly here, candidate allegation is not there against the candidate. Now, on the part of the candidate or his agent or of any other person with the consent of the candidate or his election agent, with the free exercise of his electoral right. Now, here is allegation is Lordship has seen, the allegation is, I'm just pointing out one more thing, my lord. The para 12, na? Just a moment, my lordship will kindly take up paragraph 12(1) again.
Yes.
Now, what I'm trying to show you, Lordship, my lord, the allegation is not against the candidate, but against his workers and supporters. Lordship has seen that one of the proposers of the election petition, Sri Ninia Angu, were attacked by party workers and supporters of respondent. So respondent himself is not there, according to them. It is the workers and supporters. Now, Lordship may kindly see section 100 of this act, my lord.
Yes.
I'm just reading first, then I'll submit, my lord. Grounds for declaring election to be void. Subject to the provisions of subsection 2E, the High Court is of the opinion, A, we can skip, my lord, B is important, that any corrupt practice has been committed. Undue influence is a corrupt practice, admittedly. Any corrupt practice has been committed by a returned candidate or his election agent. First is returned candidate or his election agent or any other person with the consent of the returned candidate or his election agent, or that any nomination paper has been improperly accepted, that we can skip. Then D, Lordship will kindly see that the result of election insofar as it concerns a returned candidate has been materially affected. 1 we can skip, 2 we can, so 2 is important. 2 is what I am trying to indicate. By any corrupt practice committed in the interest of the returned candidate by an agent other than his election agent. So, my lord, what I am submitting here is there are two types of corrupt practices. One is mentioned in section 101B and the other is section 101D2, which I have just now read. So far as 101B is concerned, if 101B is proved, that is enough for the purpose of setting aside election. And what is the requirement? Requirement is that the corrupt practice must be alleged to have been committed by the return candidate himself or his election agent or by any person. Party worker may come here with the consent of the return candidate. So the requirement of law is, if you are saying that this undue influence, first of all, this will not be undue influence because it is about submission of nomination paper. Assuming for the timing that even nomination paper is a part, and if you make any obstruction, that will also amount to a corrupt practice of undue influence, assuming for the timing it to be so. Even then, if your allegation is that I have myself committed the corrupt practice of undue influence, then it will come under 101B. Nothing else is required to be proved. That is enough. If you say that it is my election agent, even then that is enough. But if you say that if it is any other person, then what is the requirement of law is there you must show that there was a consent of the return candidate or my election agent. Now, Lordship will see in this paragraph, the persons against whom the allegations of corrupt practice of undue influence has been leveled are workers and supporters. That means they are any other person. They fall in the category of any other person. They do not fall in the category of the candidate himself, that is the return candidate. These two classes of persons, workers and supporters, they do not fall in the category of election agent. Well, your Lordship is aware election agent has to be specifically appointed.
Yes.
So allegation is not there that these persons are election agent. Allegation is against the workers and supporters. Act says that if you want to simply prove corrupt practice for the purpose of setting aside an election on this ground, then you have to show either it is return candidate himself or his election agent. But if it is some other person, then one more requirement is there, that is the consent. Act is very clear now. By any other person with the consent of the return candidate or the election agent. Because election agent is just like the candidate himself. If the consent was taken from the return candidate himself or his election agent, then he comes within the category of persons mentioned in section 101B. Now, in this case, your Lordship, in paragraph 12(1), they have specifically said workers and supporters. And they have, according to them, given the names of 1, 2, 3 persons who, according to them, were workers and supporters. Now, my lord, my submission with your Lordship is, in order to bring the allegations made in paragraph 12(1) within the meaning of section 101B, they will have to show that at least there should be specific allegation that this is the way the consent was taken from the return candidate or from his election agent. Otherwise, this allegation will fall through, my lord. In this entire paragraph, nowhere they have said that consent was taken from the election petitioner, sorry, the return candidate or his election agent. If necessary, my lord, I'll read it again to show that it is not there. I have read already, my lord. Nowhere it is alleged that consent was taken from the return candidate or his agent in order to commit this offense of undue influence of attacking them. And that too at the time of submission of nomination paper. My lord, it is another thing whether such attempt, if any, of attacking on the date of submission of nomination paper will come within the definition of undue influence has to be seen, my lord. I'll make my submissions on that. Now, my lord, assuming that no, they did not want to allege the corrupt practice within the meaning of 101B, but they have actually meant within 101D2. Now, my lord, will kindly see what is 101D2. D2 says by any corrupt practice committed in the interest of the returned candidate by an agent other than his election agent. Other than his election agent, by an agent, if you say that no, I am talking about the corrupt practice of undue influence within the meaning of 101D2, then, my lord, as mentioned in 101 and D, there is a further requirement. Again, D, you will kindly see that the result of election insofar as it concerns a returned candidate has been materially affected. So, if there is an allegation of one interesting aspect you will see, 101C says about improper rejection of nomination paper. But 101D1 says improper acceptance of any nomination paper. There is a difference. If there is a case of improper rejection of nomination paper, then nothing else is required to be proved. But if there is an allegation of improper acceptance of a nomination paper, there can be a ground in an election petition that the returned candidate was not of 25 years of age. As a result, he was not qualified to contest for the seat of a legislative assembly, my lord. Then he is disqualified. Then if his nomination paper has been accepted by the returning officer, then it comes within the meaning of improper acceptance. In that case, proving only improper acceptance of nomination paper will not serve the purpose, because requirement is that if it is a case of improper acceptance of nomination paper, you will have to further show that because of such improper acceptance, the election of the returned candidate has been materially affected. There is a reason. If there are 10 candidates and the nomination paper of one candidate who had not secured even minimum of votes, and his position is maybe 4th, 5th, 6th, improper acceptance of his nomination paper is not going to affect the election of the returned candidate. And that is why it comes after 101D. Similarly, my lord, if it is a corrupt practice within the meaning of 101B, then merely by proving commission of corrupt practice, either by the candidate or by the election agent or by any other person, but with the consent of the election returned candidate or his election agent. In your case, in the case in hand before your lordship, my lord, allegation is that some workers came and attacked. Now, first of all, whether it is a undue influence or not, your lordship will see. I'll make my submission. Assuming for the timing that it is an undue influence, then since you are saying that those who did it were only workers and supporters, they do not fall in the category of the candidate himself. They do not fall in the category of election agent. They fall in the category of any other person. Then, if they fall in the category of any other person, you have to say there has to be a specific pleading, which will be a material fact. I'll come to that later on, why it will be a material fact. Because you will have to prove this, and that is how it will become a material fact. This material fact is absent in this paragraph. That is my submission, my lord. So, my lord, if they want to come within the meaning of 101B, in the absence of any consent, this will not come within 101B. So there will be an absence of material fact of consent given by the candidate or his election agent in favor of the persons who, according to you, have committed the corrupt practice of undue influence. In the absence of that, this paragraph will lack the material fact. And for that, this paragraph is required to be struck out from the election petition. That is my prayer. In terms of Order 16, Rule 6 of the Order 6, Rule 16 of the Civil Procedure Code. Now the second matter. It is paragraph 12(2). Well, the note that I have given, synopsis that I have given,
Yes, yes.
lots will find. So far as paragraph 2, I have just made a short note of actually what is the exact precise allegation.
Yes.
In paragraph 12(2) of the election petition, their allegation is, in short, respondent number 1 through his party workers, again party workers, Lordship, party workers and supporters threatened the petitioner and his supporters with dire consequences if they campaign for the election in the question. The petitioner sought intervention of returning officer to provide security, but the same was denied. As a result, the petitioner was prevented from campaigning, which adversely affected the prospect of his election, and therefore respondent 1 is his agents, supporters committed corrupt practice. Now, if your lordship goes to this paragraph, again, in this paragraph also, the allegation is against workers and supporters. Return candidate through his, return candidate himself didn't go there. Through his party workers and supporters, the election petitioner and his supporters threatened the election petitioner and his supporters with dire consequences if they campaign. So similarly, and then they said they sought for security and which was denied to them, and that is how is prevented, and that is an undue influence. My lord, in my humble submission, same is the case here as in paragraph 12(1). Here the allegation is that workers and supporters, we don't know, my lord, in the election, assuming that this is correct, in the election somebody may come and say that no, I want that this should happen, that should happen. Oh, wow. The candidate has not appointed any such person. If somebody does on his own volition, for that the return candidate should not suffer. Maybe somebody has implanted him. Maybe the petitioner has implanted him. We don't know. So that is why, my lord, the Act has made it very clear that if he is an election agent, there is no question of any presumption. It has to be accepted that it is the candidate himself. The act of election agent is that of the election candidate himself. But if it is other than the candidate and his election agent, then the provision is very clear. Consent is necessary. And my submission before your lordship today is that in paragraph 12(2), lordship will find, lordship may kindly take note, there is no whisper that any sort of consent was taken. Now, in the absence of the consent, this loses the ingredient of section 101B, which says that if it is any person other than the election agent and the candidate, there has to be a consent. And the requirement is that, my lord, there has to be a material fact. In the absence of a single material fact, the allegation will fall through. And in this paragraph also, the consent part is, there is no averment that consent of the return candidate or his election agent was taken. In the absence of such averment, in the paragraph 12(2) of the election petition, the same will not come within the meaning of section 101B. And, my lord, assuming that no, it comes within 101D2, then they will have to show, my lord, that such work of threat, etc., has materially affected the election. Now, first of all, my lord, there are Supreme Court judgments which say that merely by quoting provisions of law will not suffice. You cannot simply say that, no, this has materially affected. No. How it has materially affected? You have to show by making clear averments in the petition. In what manner it is materially affected? Well, I'm giving one example. If you say that there was an impersonation which I have given in, ultimately this come in this case also. If you say that by impersonation, vote of 5 persons were cast, and there is a difference of vote between 2 persons of only 4 votes, then it will be case of materially affecting, because if 5 votes go from the account of the return candidate, then he will lose by 1 vote. So that is what is meant by materially affecting the election. Similarly, my lord, if the allegation is of improper acceptance, if there are 2 persons in the fray, and the person who is elected ultimately wins the election, and in the trial of the election petitioner, if your lordship finds that his election nomination paper was improperly accepted, he has to show that it is materially affected because it comes under 101D. It will be easy for him to show that if he is taken out from the fray, I get elected. That is how because of him, I was not elected. That is why it is materially affected. This is how he has to show that the election of the return candidate is materially affected because of this. If the validity of the nomination paper of the return candidate goes, there is no other person.
So 12.1 and 12.2 are this manner, and 12.3 is basically for impersonation, which para?
Yes. Uh, 12.3, now I'm reading my note. That the election petitioner, one of his proposer, Sri Ninya Angu, election petitioner, sentence is not very grammatically correct. They are saying election petitioner, one of his proposers, Sri Ninya Angu and supporter, Sri Katwan Mayong, were manhandled. That means his persons were manhandled and restrained from entering the office of returning officer situated at office of Deputy Commissioner Likabali, Lower Siang District at the time of scrutiny of nomination paper for election to so NM by the supporters of return candidate, few of whom are Sri Ili Koyu, then Minge Kodu and Dakde Riba and Sri Chi Kodu. Then their further allegation is that thereby the return candidate interfered with the election process, including the free exercise of electoral rights of the voters of the constituency. My lord, this paragraph possibly will go on the basis of the allegations made in this paragraph itself. What is their allegation? In the note I have prepared, petitioner, his proposer, and his supporter were manhandled and restrained from entering the office of returning officer situated in the office of the Deputy Commissioner at the time of scrutiny of nomination paper for election in question on so by the supporters of respondent number 1.
But
few of whom are
this is at the time of scrutiny of the nomination.
scrutiny.
That has already been accepted.
One or 2 at the time of submission of nomination paper, and 3 they are saying manhandled and restrained from entering the office of the returning officer at the time of scrutiny. My lord, in a
Yes, we're going to continue or
we'll continue. It will take, I'll take another 1 hour, maybe 1.5 hours time, because I have to cite some judgments also. Lordship will fix another.
some matters are there.
Yes, yes.
Uh,
I've at least argued
so
for 1
we
hour.
have, now I have up to 12.3.
We
12.3 we have completed.
Yes, ma'am.
Now rest of the para, mainly you're emphasizing on para 12 and 13.
Yes.
These are the 2 paras where the
Along with its subparagraphs.
along with the subparagraph.
My lord.
So these are the 2 paras wherein the entire corrupt practice and undue influence has been brought by
Yes.
these. Yes, Mr. Parab, so we are, part her, matter is part her. Some portion of the part of the argument is still left, by Mr. Majumdar will complete this one on the other day. And have you noted down the argument which was made by Mr. Majumdar
Yes, ma'am.
already, no? So that it can help Mr. Pathak also in the next day. So we'll hear the matter on the next day. Mr. Majumdar, we have already fixed one matter of the election petition on which you are also in connection with the
Oh, yes,
election
yes.
matter.
That-
Which
that
was
is
the
on
date?
First of May, I think.
Then if it is on 1st of May, then we are not going to fix it on the same day.
Well,
It will,
it will be convenient because
problematic.
my learned friend is appearing in that case also against me.
Yes,
Yes.
that case also. 1st of May, এটা fix করা আছে নাকি আমার election petition.
That matter is fixed on first.
First May at 2 p.m. we have fixed already. Mr. Pathak was submitting on his part, I think.
Yes.
In that matter.
In that case, now he has to reply first.
Yes.
There I have completed my part.
একটু কেটে পারি ওখানে।
First of May. First of May, I will pass on the argument matter.
I-56 2025 had Mr. D. Majumdar, Reliance Senior Advocate, assisted by
Mr. Deori,
Mr. Deuri,
SK Deori.
SK Deuri, and also heard Mr. Anpada, the counsel for the respondent. So the matter is part heard. Let the matter be listed on, yes, when it can be listed. After 1st of May, not in the first of. All are full. 13, 14 will be too late, or you wanted
Well,
8, 9?
Yes, it will be done. 13, 14, yes, 14.
13, 14, 14?
Let it be 14, yes.
14, Mr. Pada, 14?
Yes, ma'am.
14. 14. It at 2 going to be. Yes. It's at 2 p.m. 2 p.m.
13 also it can be done, madam. 13 is a Tuesday.
Oh, then it's okay. 13 is there.
13.
13.
At 2,
13.
madam.
13 at 2. 13 at 2. Information দিয়ে দেবো first or dinner. The 2 p.m. at election matter it will take time. আজ ওটা half done হয়ে গেল। So filling matters আমার form list করলে ভালো, these are fixed matters that they are already there. Otherwise ফেললে পর affect করে যাবে। আর it will take time. আপনার measurability issues কিছুমান আছে তো।
হ'ব পাৰে কিন্তু কনফাৰ্ম বেলেগ এটা ৰাতি
মই এইটো পেজটো দিলো নেকি আপোনাক একটু দিয়া নাই লিখাটো
Right.
Okay. Timing good fast.
Item 30.
1-3.
1-3. It has been rectified now.
Right.
Now just I want to ask you one thing. Are you pressing on the ground of arrest?
Lordship, that is one aspect. Other aspect also there.
Ah.
Ground of arrest, because the argument advanced by Mr. Kaushik I have heard.
Ah.
Only then on the Lordship, on the sport possession of narcotic drugs, when the offense is committed, he is red-handed caught. In that sense, he is arguing Lordship. My case is totally different, Lordship. That is why it will be
Are you
applicable.
ready to for that argument? Here it is a case of POXO.
Foxo, my lord. Foxo.
Oh, acha.
Yes. Okay. Lordship, here the petitioner was arrested, first note, 26/5/2024.
26/5.
5 years.
Hmm.
11 months he has already been completed. And the Ellie's victim girls, 2 victim girls there, their statement were recorded. Lordship.
Victim's
Yes.
statement. Victim statement means evidence is.
Evidence were recorded. This is the one aspect. The second aspect is Lordship. Although Lordship now we have been witnessing Lordship 47 notice Lordship. It is absolutely not complete Lordship. I have filed the additional affidavit Lordship. Can you see that additional affidavit Lordship? And I have the certificate to it also.
As a whole, how many witnesses were cited by the prosecution?
6.
6 witnesses.
Yes.
So these two are 1, 2.
Yes, 1.
So out of 6 witnesses, 2 examined or what?
8.
Eight
Eight.
witnesses.
Yes, 8. 6 witnesses is still to advance. And also I have the certificate copies of that aspect of the constitutional violation because his initial arrest as per the Bihan Kumar Lordship and Purvir Pukasta and others Lordship, it was per se unconstitutional. On that ground alone, he may be, he is entitled to get bail Lordship. Lordship, kindly see the arrest memo which I have the certificate copies. Lordship, just one judgment of the coordinate bench regarding Lordship 47, I would like to. If your Lordship permit. Or otherwise necessary. Lordship. One judgment of coordinate bench of this board.
And based on your thing, any other material facts? Otherwise? On other matters, you want to submit anything? In regards to the merits of the case?
Yes. Lordship.
Want to submit anything?
Merits of the case of the Lordship, already he is behind the bar more than 11 months. And already the vital witnesses, that is PW1 to already examined Lordship. And for fair defense Lordship, he should be released on bail Lordship. And Lordship, this judgment I am showing, kindly come to paragraph 19 Lordship. In view of the observation made by the ethics court, Lordship, this I will, it's like this. Lordship, kindly directly Lordship, paragraph number 21.
Paragraph number
21.
20.
The right to be informed about the ground of arrest flows from Article 22(1) of the Constitution of India. Lordship. It is a constitutional right, Lordship. And any infringement of this right, fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and unconstitutionality committed at the time of arresting the accused. Can you note at the time of arresting the accused at the ground of initial police custody, remand to the accused. This is clear terms, Lordship. Because at the initial arrest, it was unconstitutional. Mere filing of charge sheet does not validate. Lordship. This is first one. And kindly see Lordship, paragraph number 30, Lordship. 30. Lordship, it is one case cited, Lordship, the Director of Enforcement versus Subhash Sharma. Once a court, while dealing with a bail application, finds that the fundamental rights of the accused person under Article 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with the bail application to release the accused on bail. The reason is that the arrest in such cases is still vitiated. It is the duty of every court to uphold the fundamental rights granted under Article 21 and 22 of the Constitution. That's
yes.
my lord, here, regarding the merit of the case, my lord, here, Lordship, I am sorry, my lord, here total 6 witnesses in charge sheet, my lord. Out of 6, 2 witnesses examined, my lord, 2 victim girls, my lord. And both the 2 witnesses clearly implicate the accused person, my lord, how he has taken them to the, my lord, in different way, my lord, to the Hyderabad, my lord. And on that day, on their, my lord, they have committed offenses, my lord, there in pretext, they have taken to the Hyderabad on the pretext of their job or any other, my lord, and they have committed the offense. And from the statement also, it reveals that they have 161 also they have said that, my lord, they have taken with the help of the police, they have returned to the, my lord, native place, my lord, and fully implicated the accused person, my lord. Both the accused person, both the, my lord, victims are minor at this stage, my lord. As per medical report, it was 12 to 14 years, my lord. More than 12 years, but less than 18 years, my lord. And other witnesses are yet to be examined, my lord. Only 2 victims examined, my lord. Other medical officer and other IO is also yet to be examined, my lord, material witnesses. And my submission is that regarding the merit of practice, my lord, they are not entitled, he is not entitled to grant bail, my lord, at this stage, my lord. He may influence the witnesses if he is released on bail at this stage, my lord. And regarding the, my lord, non-fulfillment of the, my lord, notice 47 and 40, my lord, 50, my lord, it is a matter of record, my lord, that is already available, my lord, here. And whether these are also applicable in case of FOXO or not, I mean, that is also one question on arise, my lord. Here he is also, my lord, victim is implicated and then he was arrested, my lord, on the basis of the, my lord, statement, my lord. And in the cross also, they are unable to find out any, my lord, contradiction, my lord, in the examination of PW1 and PW2, my lord, 15, my lord. That's my kindly page their statement, my lord, evidence. And my objection is here, my lord, in this regard to grant him bail at this stage, my lord. Only 4 witnesses are yet to be examined, my lord. Thanks.
May I please announce? Doctor, firstly, this is a clear case of child trafficking and prostitution. Because in the evidence, the one of the victims has clearly stated that they were told to have such kind of relationship with other men also. And they had taken them, the petitioner had taken them to Hyderabad for the said purpose on the pretext of job. So it's a case of child trafficking and prostitution. It's a very, very heinous offense. Secondly, Lordship, the petitioner is from South Salmara. The trial is going on. He was arrested in Hattigup. The trial is going on in Guwahati. Now, if he is released on bail, he will go back to his native place, and there are high chances that the trial will be hampered. If the trial is hampered, the victims will suffer grave injustice in the instant case. Thirdly, Lordship, so far as the grounds of arrest are concerned, that it was not stated. It is clearly shown in the additional affidavit, section 50 notice, that he has been arrested in connection with this particular case. The case details and everything were already given. So giving the details of the case in my humble submission are sufficient cause which needs to be known by the arrested person, and the details of the said PS case and everything was sent to the family members of the petitioner also. So in my humble submission, that is sufficient.
That type of offenses in such a FOXO cases. He was arrested, my lord, he was given the case number and anything else, my lord.
Okay.
Lordship, may kindly peruse the depositions.
No,
Depositions
one-
are very serious.
my-
You're saying that it's not only a case of physical assault, but I mean sexual assault, but it is a case of trafficking also.
My lord.
Yes, Lordship. Because the PW2 has categorically stated that she was taken to Hyderabad in an inebriated condition. Out there, she was given pills because of which she used to get unconscious, and thereafter sexual assault used to be committed upon her. So she is not in a position to say as to who is committing. It might be the petitioner also, it might be
Any
this
dimension.
Dolly and Dolly's husband. They were kept in the residence of one lady by the name Dolly along with her husband. So it might be the husband also, it might be a gang rape also. She was in an unconscious state of mind.
Lordship, serious type of offense.
Replying this lordship, lordship, here I am seeking bail lordship. Here lordship, already the victim galore examined lordship, the evidence were recorded, and this is more than 11 months lordship. And lordship, other than lordship, his arrest, initial arrest was vitiated lordship. On that ground only he is entitled to bail lordship. Itself lordship.
Okay, so I passed.
Yes, lordship, scan copy is there.
Oh, it's a scan copy.
Scan copy. Hello.
Oh, that will be the chamber.
35.
May it please your lordship. Lordship, I was arrested on. I have been languishing in jail for 554 days till date. Means 1 year, 6 months, 6 days, lordship. And I was arrested on 18th of October,
1 year, 6 months.
6 days.
You are arrested on
18th of October 2023. That is
23.
23, lordship. And the charge sheet was submitted on 5th of April 2024. Charge was framed on 28th of August 2024. And till date, no witnesses have been examined. Lordship, I would like to take two major grounds here. This is the first.
How many witnesses are cited witness? Cited
My lord,
witness.
total
Seven.
eight witnesses, my lord.
8 witnesses
Seven.
cited.
No, total 8 witnesses in the charge sheet, my lord.
Okay.
And after this, there was about call for my lord in the earlier occasion, my lord. Perhaps not. It was came in the month of December, my lord.
Lordship.
Yes, there was in the month of December, my lord. From that, they have
Status report in the
taken
month of
time, my lord.
December.
My lord, scan copy.
Scan copies are
They have
here.
taken time from that period. my
As
lord.
per my information, no witness has been examined till date. I am the advocate in the trial court also, lordship.
Astro order to the- Last date of order.
Request for appeal state as report, my lord, here in the month of December, my lord. That was report. my lord. Good.
7 wireless fixed. Yes, any other submission?
Yeah, lordship, my first submission is the ground of arrest, lordship. With regard to ground of arrest, what is the ground of arrest, lordship? In Bihan Kumar, Mr. Justice Kotishwar Singh has said in the last paragraph number
Just
3,
a second.
observation.
Your case is whether your position was there or you have directly
Yeah,
read
in my
comprehended.
in my position. That is the ground of arrest, Lordship. In my case, I may be aware, but my family members are not aware. It is mentioned. It is mentioned in the paragraph number 3 by Lordship, Mr. Justice Koteshwar Singh. The requirement of communicating the ground of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other persons as may be disclosed or nominated by the arrested person. So as to make the mandate of Article 22,
48 notices there.
My lord,
48 notices there or not?
paragraph number 14, Lordship, in the LCR, Lordship.
Paragraph number 14. No,
14
no.
and
14.
17. 14 and 17 is the fifth.
LCR.
My lord, they
Yes,
have to
Lordship.
bring on record, my lord, when they are 47.
I have the
47
certificate copy, Lordship.
Not given
No,
to them.
it's okay, we have received the copy and no, I'm not on that. I'm saying that 48 notice was also issued or not.
Yes, issued, but only information, Lordship.
That's what I'm saying. Question is that
Only
these
information.
matters are being kept, all matters, this kind of matters will be deferred. I think.
Lordship,
Because Monday, Tuesday, some observation will be there, and
Yeah.
then only I'll pass the order.
My lord.
Lordship,
So
I
these
ask
things
one,
will
one
be
more
deferred.
ground, one more ground I had, Lordship. Other than this grounds for arrest, and that my case is prospective, applicable in prospectively, Lordship.
No, that is understood.
Okay. The
You're
next
not on
ground is,
denying that.
Lordship, my next ground is prolonged incarceration, Lordship. In the case of
No, there are prolonged incursions and matters are there, I know, because there are the circumstances of the cases are all are different in fact. So now here in this case, we are not in a position even to say whether the last order was on 3/12/2024.
My lord.
Next date was fixed on 7/1/2025. Whether there is any evidence.
My
for
lord, that
examining-
was.
no evidence is till date.
You have the information.
Yes, Lordship. I am the advocate in the trial court, Lordship.
So you are the advocate
Yes,
in the
Lordship.
trial court. And that may be okay, but the question is that
My lord.
I have to deal with that case, then only I'll pass the order.
My lord.
So it will be deferred. We'll fix another date on
My
it.
lord.
Or in the meantime, you may call for the updated one.
My lord.
That will be the position.
Lordship, can I make-
Because in your case, it is the case where
Yes, Lord.
the recovery was
Right.
directly from you and
Right.
you were caught red-handed by with
Right.
the contraband. So that submission was made early in the morning
Right.
hours by Mr. Kaushik. So I'll have to go through.
I
the
have heard, but
You have
the
heard
thing is that the arrest, I may be aware of the arrest, grounds of arrest, and that has to be in written, Lordship.
That is.
That has to be in written. But my family members who will engage in counsel, they don't know what is the ground for arrest.
Yes, that may be one of the aspects.
That doesn't serve the purpose of the.
Important issue
Lordship.
on that. Their family members may not be aware of.
Yes, Lord.
That will be considered. We may hear on that also.
Yes.
So let us, your date may be fixed. এখন লিখিব simply.
First of May, we can.
The
That is
first
fixed on
date
30th.
is on 30, the 1st of May will not do. We have lots of matter. 1st of May that your case will not reach even.
Right.
1st of May again, this ownership matter
Ownership
is there.
matter.
Second of May.
At 2 PM it has already been fixed. So with other cases will not be heard. Circular assembly. No, that has been deferred, no? Yes, ma'am. At 10:30. So we need a court. Okay, for that file. Second, half of phone or date overlapping ones. Either maybe 5th or 6th.
Second or third May can be given.
No date is there. Yeah, considering she's saying in fact, 5th of May corridor. I also call for the present status report.
Up to
of
date
the
status report.
Case, up to date status report of the case. Rest you will do the need for 5th of May. We are listing it. Right. Okay.
May I please, your lordship, 36 and 37, both are my cases, lordship. If lordship take up the 37 first, lordship, my learned senior brother will argue that case, lordship, same similar footing.
No, but the question is that I'm just asking you whether your ground is
Oh,
also.
no, that is why, lordship, I am.
Ground of error.
Lordship, that is why I wanted the 37 may be taken up first, lordship.
Then I'm not going to hear. This ground of arrest, let me be, let the order be passed first, and then all matters are in the morning also only I have to say. The matters will be deferred, all matters. Because they have to, some observation has to be there, so that's why they defer all the.
Got up some judgment.
If any other thing is there, then look here to it.
No, I just wanted to point out
Mm.
that I think Rishi Kaushik made an argument. I was here at that point of time. What he was trying to project, I heard it. That is why I was trying to say that I will counter that. Like, if your lordship give me a few minutes, I will counter that because he referred to, I think, a judgment of Bansal and one judgment of Limai, Madhu Limai. Madhu Limai judgment and Bansal judgment he stated. And therefore he stated that your lordship will go into the fact whether the person who was, I think, caught red-handed or something like that. If that is so, then the notices, whether that will be under section 50, the notice of grounds is required to be given or not. In a sense, if your lordship see, I suddenly shoot him here and everybody's seen me. Is it necessary that I should be given the ground of arrest? These things, your lordship, yes, obviously it will come in terms of why should it be needed. But what has happened? The court itself in its judgment has already stated why it should be given and what is the role of the High Court and the other courts to do in such a case. That is what I want to point out. If your lordship hears me and then makes whatever decision your lordship, it's up to your lordship. I'm not going.
Then your
I'm to
matter
point out.
will be listed after 30.
After
30.
Kuntu.
Other matter will be heard in that matter, then only will pass the orders.
Then
otherwise,
that
what
matter I'm not
as
arguing. I'll be
I'm
arguing
saying
my matter.
that there should not be any differences in the order. There should be a parity. has
Yeah,
to
that
be
is
there.
why.
That's why I'm
in
just
my
not,
case, yes.
I'm not.
What
want to
I'm
pass
trying,
any
no,
order.
in fact, why I'm saying that, Mr. Kaushik and me argued just before this case, we argued the same issue before Justice Kaushik Goswami.
Mm.
This issue he raised, I have also argued the
Just
matter.
tell us the number of, can you tell us the case number of Mr.
No.
The Justice before Justice Kaushik?
No, that order has not been passed.
No, just case number, case number.
Case number is basically, yes, case number.
Item 28.
That case, your lordship, the order has not been passed, fixed tomorrow again. For
No,
further
I've been just seeking the case number only.
Okay. This is item number 624. No, BA 624/25. Ajibur Rahman. Anyway, that and similar argument has been made and it has been further hearing has been fixed tomorrow. I'll argue that matter tomorrow anyway. So since the same issue has cropped up, that is why my learned friend said, why don't you point it out before this honorable court? That is why I pointed out what is the role of this Honorable High Court as well the other court. The Supreme Court has stated that. Secondly, he actually in that case, not this case anyway, in that case he referred to two judgments. One is Bansal, Pankaj Bansal, and one is Madhu Limai. Madhu Limai, though there is a line where it says that what happens when there is a somebody is caught red-handed. That part, after considering everything, Madhu Limai said that no, you have to follow 22(1) of the Supreme Court. That is a mandatory provision that has to be followed. So Madhu Limai was given bail in that case.
Bail was given, yes.
In second case, in Pankaj Bansal has been discussed by Prabir Pukasta as well as by Vihan Kumar. So Prabir Pukasta, considering the decisions of Bansal, has held that the decision is correct and it should be followed. Then Vihan Kumar came and Vihan Kumar has made it very elaborate by making a specific directions to the Honorable High Court as well the all courts of the country that what they had to follow. There were two directions given to the High Court as
Yes,
well
obviously.
that you should only look into this fact. First is whether the grounds have been given or not, and secondly, if this has been given, whether that is as per the. These are the only two conditions which has to be, and that was the directions given to all the. So courts will be bound by only these aspects, cannot go beyond it because it's a fundamental right.
Okay, then we'll fix your matters, two matters, because all these same kind of matters will be fixed in the other dates. We'll pass the order, I'll pass the order on 30, it will be heard. 30.
Then in that case, your lordship, that day, I may be allowed to submit my submissions with regard to these factors which I have made it out now.
On 30, you want to fix it?
I will be.
The hearing be there, let the hearing be there because other side also have given time.
Okay.
They may also prepare in that
Okay.
case. So it will be heard on 30th. So your matters may be on 5, 6, 5 or 6.
No, then there will be a issue if your lordship goes by any order, then it will be difficult to revert back to another order or something like that. That is why, if it is fixed, it should be fixed with the other matters together.
On 30, you're
Yes,
saying?
yes.
The party was on. Both matters are same.
না এটুকু বুঝি পারছি মানে আজি হিয়ারিং না যায় যেহেতু আমি না যাও ফার্দার হিয়ারিং In fact, there are other 3 matters I have today, all these on the same condition, some same grounds. I think
Both,
item
37 you have and then
this is 37, 37, 33, 37, 43, 44 and 40
you're 43, 44, 44.
and 40, all these 3 on the same ground.
The same line, 43, 44, 45 and 37 also. you have.
37, this is 37,
Both
which I
will have
am
also 36.
36. My
Mr. Munir has 36.
36 also.
Only
I-
1% will argue, lordship, let it be take together, lordship. One will argue, then lordship will find a reasonable
Then
lordship. to
30
pass
may
it.
not be possible, 30 may
Because
not be possible.
that part, lordship, I am sorry to say, lordship, if that part could not defend the side, lordship. It could not produce any judgment and anything like that, lordship. If lordship judgment goes, lordship, against us, then thereafter, lordship, it will be a great difficulty, lordship. That is why, lordship,
I also feel there will be another judgment coming in between by that time. And
Yes,
that
it
will,
is before the Supreme Court, I
no,
believe.
that will not come. That I have,
That
I have
also,
got,
that also may come.
there are 2 issues coming in that case. One is with regard to the, some fact checking is there, no doubt. They have not actually, what has happened, your lordship, they would have been aggrieved by this order of Bihan Kumar, or they should have gone for a review or something that they have not gone. But this is another case from Bombay High Court, which has come before the Supreme Court, where there was I think, hit and run accident.
Hit and run
Yes,
case.
that case was heard. There's 2 points were raised, whether it should be elaborately done or it should be on the basis of facts of each and every case.
and every-
That is one. And second ground is that now what has happened, your lordship, on the basis of this violation of Article 22(1), the bails have been granted. So what happened, since this holds that the arrest itself is vitiated, so there is no arrest. When it is no arrest, whether the person can be arrested subsequently. So that question will also come up. These are the
Okay.
2 points.
Ah,
So it will
yes.
take some time. We are not on that because before that judgment comes, this Vihan Kumar will have to be followed. There is no other option because there's specific direction by the Honorable Supreme.
Okay, then we will do one thing.
Since
If
I will
suppose-
argue
no,
for
no,
all
no,
the
if
cases
suppose-
together.
No,
that will do,
that's
Lord.
what I'm saying.
Yes.
If suppose the other matter is heard on 30th,
Lordship.
then order may reserve also, so that we can
Yes.
hear you
Then
also.
it is not. A
In that case, second, third, we are not flourishing with the cases. First, we cannot give, first, only again the election matter is there.
If it is on 30th, your lordship.
That point, lordship, it is.
If it is on,
This is.
Only least foolish.
This is first. Second is 40. Including one civil case, 15. This is 15. It is second. Was it third or fourth one?
It's point, computer fit again.
বেলেগ মেটাৰৰ লগত কৰি দিলে ভাল হৈ আছে কাৰণ সেইটো টাইম বেছি নালাগিলে since I'll be arguing all the 4 or 5 matters together by one person, that could be taken up because it will not be individual
Below the 30,
or
because
30 at itself. Because that case, along with the 5, whatever 5, 6 cases, whose case ever is there, I'll argue these matters together at one go. Your lordship can hear all.
lordship will see that we are not on the merit of the case, only one.
Yes, yes,
lordship
obviously,
there.
obviously,
You
obviously.
argue it, lordship, if it is all case, fate will be same, lordship.
No, if there is, there will be a
Maybe it's
different,
different, but-
if somebody has grounds have
other
been given,
grounds.
then it's a different.
That's only the issue regarding notice, Lordship. That point will be clear, Lordship. All cases will be same. If someone has got another grounds, Lordship, they will argue differently, Lordship.
Oh, matters, lots of matters have already been fixed, and that is the issue. Otherwise, okay, then yeah, you have 5 numbers cases,
Yes.
including Mr.
Including
Modi's case.
Mr. Modi.
These two cases are minor, one he will lead, Lordship.
No, I know.
Lordship, 36, 37.
37 or
Yeah, I'm not
36,
gonna-
37.
3, 44, 45.
43,
that's
44,
fine.
45. List here, going to, yeah, second. Okay, we're listing it on second, but the rest of the matters may not be listed on second. Let
Take
us
it easy,
leave it
Lord.
there. Then it will be listed, your 36, 37, 43, 44, 45, we are listing on second.
Lordship.
Lordship, and regarding that, which is already fixed on 30, Lordship will.
That will be
That
hard.
will be hard and.
That will be hard, order may be reserved.
Order to reserve.
After hearing this on second.
Yes, then only.
That will do, Lordship. Otherwise we will be in big trouble.
It's very much. Much obliged. to you.
Much obliged, Your Lordship.
Because jail is almost.
Empty. So what happens if your lordship, this order follows, that the re-arrest can be done, then again it will be full. But it is good for the lawyers, your lordship, we can come again.
He can come again.
Twice for the same person. Much obliged.
Oh, okay.
Everyone is getting see my luck, Lordship. This is my first case then today.
Sorry to interfere, Lordship, my case 30, item 35 is the similar, like item 45,
Now
or similar,
see,
out of similar,
This may go by that way or
out of
this way.
same FIR, so
No,
Lordship,
this way or which one? 35,
35 and 45,
35 and
45, sorry, 43,
Achha, 35 and 43
43,
out of same FIR.
same FIR.
Okay, then
And
that
it
too
is
fine.
on second
Okay,
on
okay,
my
second.
case also on second.
Okay, second, okay.
Okay.
So you have raised one issue I have already noted down
Lordship,
regarding the notice under 48.
Lordship.
Okay.
Obliged.
Yes.
38.
Just tell us, Mr. Khan, same thing here
No.
or
No,
is
Lordship,
it different?
intermediate quantity.
Quantity 48 days in custody,
48
days.
50 days.
50 days.
You were in custody for 50 days.
50
And
days.
what is the position, Mr. Goswami?
6-3 report.
What is the your, as per you,
FSL we
FSL
have not
report is
received.
already
FSL has
collected?
not received yet.
Not yet collected.
40 days custody.
FSL is
Another
still
forensic
waiting.
recovery was made from this time. Expedition.
Here, Raleigh, give out 40 days in custody. Okay, 50 days, 50 days in
50
custody.
days, only. Considering the length of
Length
it.
of detention period, and then for submission, your matters are
Kali
done,
is there,
but FSL report is yet to be collected. You can give out. And thereafter, this things, the probability of, whoever is submitted, the probability of balancing the charges within 9 June may not be possible on the part of the island. So considering the length of detention, this is about. To whose satisfaction this one?
Special Judge Bangladesh.
Special Judge Bhawan. Okay, we are considering the length of detention
Fine.
only, we are releasing you on it.
Obliged.
Special Judge Bhawan.
39.
Yes, Mr. Nawaz, same thing or
No,
it
my
be
lord.
different?
No. 82 days in custody, my lord.
Okay.
25, 1 capital, double A, my lord. Arms Act.
82
82
days.
days, my lord. Two brothers had a dispute over land dispute. So one brother,
I have.
yes, my lordship has heard the
other
matter.
day,
Heard the
yes.
matter, yes. But
Huh.
CD was not available, so your lordship had deferred the order, my lord. The CD was not available on that day. But I had
Okay.
submitted on merit, my lord. So
Yes,
two
yes.
brothers, one planted a weapon, a gun in another brother's house, notified the police so that he could be framed in the case.
Hmm.
Subsequently, police found out that this one brother had actually planted the case.
Hmm.
He was arrested. I was the supplier of that gun. That is the allegation against me. Perhaps material will also.
Everything is clear, that he is the provider of the
That will be there, my
guns
lord.
and other part.
In the first day also, I had admitted that this is most likely a true allegations. But I am in jail for 82 days, my lord. So considering that aspect.
Other material, so he is the main provider of the guns and other fake goods which were planted Bada's house.
Brothers.
Length of detention, other materials are there also.
Heard Mr. S. Nawaz, Delaney counsel for the petition. And also heard Mr. D.P. Goswami, Delaney additional briefing, as on behalf of state respondent. This is an application, the section so and so, in connection with so and so. Did you receive? Where is this? It is submitted by Mr. Nawaz, Delaney counsel for the petitioner. That it is a case wherein one gun was planted only to
Gun was planted in Krishna Ram's house by Ramji Ram.
planted was plant. But they are also accused in that case. No,
Yeah, Krishna Ram is not an accused. Ramji Ram is accused.
Ramji Ram. Ramji Ram planted the
Gun in Krishna Ram's house.
one, the two brothers out of one. No, no, one brother Ramji Rao.
Ramji Ram.
Ramji Rao had planted one gun in the house of Krishna Ram.
Krishna Ram.
Krishna Ram. Only to this.
Because of a dispute, financial dispute between them.
Only because of a financial dispute between them. However, the allegation against the present petitioner is that he supplied the gun to the to said Ramji Rao, the one of the brother of the Krishna Ram. Namgita Raman Silva, yeah. Mr. Nawaz further submitted that he is in custody since last 82 days. 82 days, and hence, considering his length of detention, he may be released on bail. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next, Mr. Kuswami, the learned additional PP submitted in this regard that the present petitioner, there are sufficient incriminating materials against the present petitioner who planted the who supplied the gun to the one of the co-accused to so that it can be planted in the house of one Ram Krishna Ram. However, he submitted that there is sufficient progress in the investigation of this case. If FSL report is not received, but however, the FSL report is still awaited. Next product, considering the submission for without going into the detail of the merit of the case. One is Ramji.
One is Ram.
One is Krishna.
Krishna.
But still they are fighting. I have met when I was an additional CGM come Teshpur. The party came, one lost the FIR, he is Gulab Khan. And the against whom he is Rose Khan. I thought this is not see.
Their names did not have impact on their characters. Right?
No.
But this will be to the satisfaction of CGM.
CGM.
I'm deep privileged. May I please also?
Just first tell us this is
No,
for your against this one?
nothing to
No.
do with that, my lord. There is something, but I'm not that on I'm not on that, my lord. This is a second FIR, my lordship, in which we are
Services
seeking
awaiting
bail.
here? Services awaiting?
My lord, one report received, my lord, regarding service, my lord. Also, can be paid.
Report is already received.
Already received, my lord, but
My lordship.
Over phone, it was requested.
My lord.
I mean, it has been requested over phone to
My lord.
inform the complainant and the director to appear before so and so. Anyway, if there is sufficient, then we may appoint otherwise
My lord.
cases of
Ma-
6 POCSO.
My lord, but this is a second FIR. Only earlier FIR on the same ground, trial is good, the record which is on record.
No, but if you take that ground, you can come for quashing also in
Quashing,
that
my
case.
That
But
will be
bail,
done.
at present, we don't have
At
anything
present,
before us.
nothing
Well,
is
in
there,
the
my
report,
lord.
it reflects that they are in the Patasar Kusi, my lord, the informant, my lord.
I
There
guess
is no
we can appoint one amicus so
Right.
that make
Right,
it
right,
observable.
right.
But the question is the second FIR is, I can understand.
Uh,
Second FIR may not be a place, but the you can go for quashing
Quash.
also and
Quashing,
for
but
bail,
he's inside, my
there's
lordship.
as there's
Okay,
a
my
law
lordship.
that we have to hear the otherwise. So we are not wasting any time. We have appointed, we're going to appoint the amicus today itself.
Yes,
So
ma'am.
that the matter can be heard on the next day. And otherwise, we have received the CD also, no?
My lord.
CD will be retained.
CD will be retained, my lordship, and I have filed one additional affidavit.
That has to be called for or is it
That
already
is
there?
already there, most probably.
Already there. We have already tagged. It is already tagged.
And the whole record of Patasar Kusi case, I have annexed in the additional affidavit.
In addition, affidavit. It's here. No?
Yes.
That
Okay,
was
it
not
is
a
already
POSCO
been.
case, it was a promissory marriage case. Actually, POSCO is not there itself, if the honorable court kindly sees.
She is not a minor.
In 2023, my lordship, they had a love affair, ring ceremony was done. In the affair, everything is written. And subsequently, what happened? That marriage did not took place. So mother lodged an FIR that my daughter such and such was in an affair with that accused person.
they had a ring ceremony, and subsequently he did not perform the marriage because it shall be married later on. And as such, FIR was filed, 406 charge sheet filed, trial is going on in Barpeta PS.
Only 406.
406.
That is that case.
That case, my lord.
Why 406? What was there? Any entrustment was there or what?
No, that,
Ring.
that girl, my lord, she promised to marriage.
The promise is to marry is 406. That's why I'm saying. Is there any entrustment of the property or anything, any entrustment was there?
342, 406 IPC. Charge sheet filed. 342 and 406, my lord.
342 and 406.
Yes.
কেনেকে দিলে হে?
Original record আছে, but the trial solely আছে. Trial is going on.
Well, here is the present case, POCSO case that already was notice was sent, my lord. Lordship may upon or MRS my lord, then Lordship may heard them.
See, then we here
My
we
lord.
will see
That
the
case
matter.
is different, my lord. They may go for.
My lord, it's the same cause of action.
They may go.
Subsequently, what
passing, my
happened,
lord.
after 3 years, 2 years, she came here in Guwahati, and before the Commissioner of Police in June 2024, she lodged another FIR that while my marriage ceremony was about to be performed with that accused person, while I came to Guwahati with that accused person to his mother's home, he had committed something, and at that point of time, I did not attain majority.
Then you cannot say exactly it is the second FIR in fact.
No, in the
Because
first FIR,
she brought the cause of action a bit different way, in fact.
in earlier FIR, she wrote that I was brought to Guwahati, kept in Guwahati with mother-in-law and all, mother and all. But that thing was not there, physical relationship was not there. Second, after that, she lost this.
Okay then.
But can it be already, my lordship, 42, 43 days behind the past?
As you've seen, our condition is a fixed matters
I-
are more
I-
than
But in this
20,
case
30
also,
is a
we can
fixed
see
matter
that
থাকে।
if it was a genuine case, if he has done something wrong intention, taking a minor girl, doing something like that, I would not have pressed. I would not have. But this case, my lordship, marriage was about to be performed. Subsequently, marriage did not take place. Filed one FIR under 406, charge sheet has been filed. Subsequently, again, you come after 1 year and file a case before the Commissioner of Police Guwahati and get it registered under POCSO Act, saying to be a minor.
But while at the time of investigation, the police whether inquired about that her age, regarding her age
That
or
nothing
whether
come
any
back-
collected. Or
That
there
will
may
be
be
on
in this
diary,
case diary.
because earlier case there, she was not a minor, nothing was there said to be a minor,
Okay.
earlier case.
Hmm.
Subsequently, she became a minor.
Heard Mr. M. Karodia, the learned counsel for the petition. And also heard Mr. B. Sharma, the learned edition PP, appearing on behalf of said respondent, CD received. However, from the service report found in the case diary, it is seen that the service is already completed on the respondent number 2, and the police has, or IO has already informed the respondent to appear through telephonic message also. In that context, let amicus be appointed to represent respondent number 2. কেনেকুৱা এইটো এইটো আবার কালি এজনক দিছো মানে পড়িয়ে আছে এদিন পূজা আগরওয়াল as an amicus appoint করে দিব registrable to the needful CDB retained till next date of listing list accordingly. Yes, see, before 5, 6, 7 don't have any date.
Too long, my lordship.
No, we don't have any date. That's what just I'm consulting with the 3-4 times,
Actually,
then
what
only we
happened
fix
was
the matter.
He is behind the bars. It was actually filed before the verifications. And subsequently, when we submitted, Honorable Court said that it let it be fixed on 24th because it is not my weeks. Otherwise, it would have been listed on 10th or 9th itself, the earlier occasion, but that time also there was no.
Jump করে দিলাম। 5 or 6 দিতে পারি 6th of May.
And CDB written one.
CDB.
41.
This letter.
My lord.
Order was passed before the investigation. And the ministry was given a mandate.
My lord, yesterday, my lord, it was, as per order, my lord, yesterday, my lord, we'll have to go to the appropriate bench, my lord. Co-accused was already, my lord. Case was
It
disposed.
was earlier rejected.
No, my, no, man, it was disposed of by the Justice M.K. Konita, my lord.
My lord,
Then dispose of the second bail application or what?
No, no, co-accused, co-accused.
Acha,
my
acha,
lord,
go
two persons were arrested on same footing. One is granted bail by Honorable Justice Mr. Kolita. And that order is this file is tagged with this record, my lord. This is the-
It was perhaps wrongly came to the, yesterday it was came to the court, my lord. And lordship, after hearing, my lord, it was referred to the appropriate bench, my lord.
appropriate bench, but registry had put up a note here.
My lord.
On the basis of the subsequent notification. That
Wow.
notice from wrong list.
Indian roster naik na.
Huh?
Indian roster naik na.
Now, Mr. Chaudhary, just I want to ask you one thing. Are you on? This is also a case wherein the ground of arrest you have taken.
Yes, ma'am, I have taken.
Then we'll fix the matters, all matters after second or third, second week. You have already heard, I think. I have already in the morning hours only that was there.
My humble submission, my lord, apart from the arrest procedure ground, my another ground is parity, my lord. Because two persons are arrested on the same footing. One is granted.
Parity in that case, that's why I'm again saying that if it is, it have to be appropriate bench. Otherwise,
Then-
because now see, the question is that otherwise you have also seen that we have granted bail in many matters,
Yes, ma'am.
considering this basically the ground of arrest.
Yes.
That is obviously it's a violation of Article 22. But the question is that for our morning hours, we raised another issues by Mr. Kaushik and Mr. Yasmin, the senior counsel, also he visited, he is going to argue on that matter on the same specific points. So since then was this, I thought that there should be an order, parity of the
Right.
order also, because it cannot be held that your petitioner will be granted bail, the others may be rejected. So that's why I am saying that it may not be considered at this stage. So
But
your
also-
petition, if it is before this court, then obviously it will be after 2nd of May.
Then my humble submission is absolutely prerogative of your lordship. You may, lordship may refer it to the appropriate bench.
We had already referred before the appropriate
Yesterday.
batch yesterday, and Resti had put up a note here. Resti had put up a note that he is not taking the criminal roster. That is why it is has to be, because one this notification, one, if someone is holding this exclusively civil roster, then may not be put up. Or if suppose civil roster along with the criminal cases are also holding up, then it may be transferred. Or if one rejected by a senior bench, that has to be go there. So these are the notifications, subsequent notification. That's why I'm saying, so do it one thing, otherwise, I just say, will not mention anything, we're listing it on 6th of May. Before they raise to you may make a prayer to list before the appropriate, because in the next week, there may be changes of the roster also.
Otherwise,
Changes
your
of
lordship may fix it on 30th of
30 is not possible, because 30 and 2nd we have already fixed. Second loss of matter said there, 30 is there, 32, I'm going to reserve the order also for some reasons. So that's why I'm saying it may be fixed on 6th. I'll just simply pass the order list on 6th.
Right.
You may approach the registries to get it listed before the appropriate batch.
Right.
Because I had already hearing your submission on other submission from the other side. It was listed before the appropriate batch. But registry had to put up a note and then it was changed before this. So what I come karo, simply list on 6th of May. Otherwise, we are also granting bail, because if the argument comes in that way, it may benefit you also, it may not also.
It will be very
Otherwise,
clear.
my lord, Bihar is very clear.
Otherwise, to some extent, it's very clear, but 2-3 issues are there which raised by the Mr. Kaushik in the morning hours. That is all a concern little bit. Otherwise.
My lord.
Because in Bihan Kumar, it is also observed that even after the filing of the charge.
Charge sheet, yes, my lord. Oh,
that
everything
can
will
be
go on.
everything will go. So that is the view. So now the matter is pending, also pending before the Honorable Supreme Court. Let us see what is the next come. Otherwise, we'll.
My lord.
42.
Wait, please, Your Lordship. Lordship, this matter was listed yesterday also before my lords. But 41 days behind bars, my life already. And quick case has been granted bail, my lord, in this matter.
Yeah, your CD was there lying.
CD,
there.
yes, yes.
Yeah,
Today it
court,
is,
my lord, but
Yes.
one thing is there, my lord. Yesterday that case was disposed of.
Ah.
That co-accused, my lord.
No, maybe it's okay. If it's allowed or disposed of, it doesn't matter. It's only rejected, then it will come.
My lord.
Was it?
Notification says so.
41 days already behind bars, 18 years boy. His results are out for class 12. Now on 15th is the last date for admissions for graduations, my lord. And under these circumstances, if it's not granted bail,
My lord, my
then
submission
it
is
will
that
be-
that co-accused already, my lord, co-accused case was already disposed of by this court, my lord. Whether it will go to the death court upon.
No. As per notification, it doesn't say so.
My lord.
Then again, it's not allowed to. It's not a question of. It is allowed or allowed or rejected.
But disposed of.
My lord, bail application, if allowed, it will be disposed of.
Disposed of
There's
by
nothing
the
further
court.
to do in this matter.
That line is there, pardon.
No, it is rejected or
No,
allowed.
no, it's allowed, my lord. He's enlarged on bail.
Allowed or rejected, my lord, only disposal, my lord, disposed of. That word is there, my lord.
My lord, we see the para 10 of the, my lord, it's allowed.
No,
No,
allowed.
no, it is that matter, but এখন মানে
I say, but it can be taken care now. It's been done. Registry को अपन खबर नहीं। Registry में से FIR देखिए।
It has to be there.
My
only.
lord, that's why.
What
The-
realistic people are.
My lord,
they
then
should
they
see all these
my
things
lord, that is.
because it is confusing and again for these reasons.
In the
Yes.
morning also informed my lord, that court, my lord. It was disposed
My
of
lord,
yesterday. my lord.
yesterday the CD was there, my lord.
CD
The
was
today is
there.
my lord.
Yes, obviously.
My lord. And that case also allowed on yesterday.
My lord.
So it
The
was-
registry has been listing it in this manner, my lord. Now
Yes.
41 days, my lord, 18 years.
Obviously, I can understand. He is a 18 years old boy.
My lord.
Well, he's
But
not
now
even named in
notification
the FIR.
says the other
My
way.
lord.
He's
You
not
see the
named also
notification.
in the FIR. He's been just implicated through an UPI ID. So that cannot be only ground to keep him behind bars, my lord.
কি কৰিব এইটো কিয় এনেকুৱা কৰি থাকে that should not be কাৰণ মানুহৰটো legitimacy there also
My lord.
otherwise harassing the other party also দিটো হ'ব নালাগে না registration
My lord, they have not verified perhaps. They have not verified
চাব
the
লাগে
same FIR case, same in the same court, my lord. It may be fixed on same court. my lord.
but pending is very different নেকি
No, my lord, order is already.
pending or question is very থাকে নেকি মানে if suppose I don't know what is notification if it is disposed of তেতিয়া তাতে দিব লাগে but it was
এনে
pending
কৈছে,
before justice Park and before this court also. In that case whether it can be applicable pending
তাতে
here
কোনো
before
pending-
us it is pending and before justice Park
IT
also it is
also
pending in that case whether it can be disposed
খালি
or
disposed করবো।
order to হলে তার যাব but before disposal it was
Oh,
pending.
no, no, no,
In that case usually it can be
My lord,
one
that
thing
may-
is one thing is there
My lord.
when it was listed before this court, at that time the case was pending before Justice Pathak.
My lord.
And similarly, out of same FIR maybe, but it is pending before us. But question is that the bail application assigned to a single bench in that event, all the bail application arising out of same FIR will be placed before the one honorable judge for disposal. That is the case.
Satsime fix it tomorrow, my lord, on that, my lord. And the special direction may be given to the registry, my lord, to fix
He
that
is
matter.
suffering.
My lord, that is
Yesterday also
suffering.
same pending with
My lord.
CD was,
CD
yesterday it was available.
My lord.
Yeah, yesterday.
My lord.
He could have made a submission before yesterday also in that
Yes.
case.
My
Then
lord, my lord.
it
That's-
could have been appropriate bench.
My
We
lord.
can pass the order on appropriate bench in that case.
My lord, because seriously this has been coming before my lords and the other bail application has been coming before Justice Pathak.
Because
So,
he is also senior
He is
bench.
also
My
doing
lord.
the special acts, IT Act.
Special
So,
acts.
Maybe that was the reason for bifurcation. My lord may otherwise
Bifurcation.
direct it to be taken up tomorrow.
My
in
lord.
the
Tomorrow
registry.
I think you should see, yes.
One of the CD may be retained in that
Mm.
case.
Uh, this before appropriate bench on tomorrow into date, tomorrow 25/4/2025. CDB written till next date of, till tomorrow, till next date, okay. Next date of listing. We are directing to list it tomorrow only.
My lord. Before the court, my lord.
Before,
We'll pass the order, copy of order will go
my
immediately.
lord may indicate the code, otherwise again they will list it here. Because I think there is some misconception going on out there.
Indicate code को भी dim जाना, dim number.
Appropriate bench.
Huh?
Or before other bench not holding criteria. Entire benches, sir. No, other.
We are listing it before the appropriate bench
Hello.
tomorrow itself.
Hello.
Or for better verification or any, you can approach the registry also. They may set aside because you can apprise the registry regarding the facts of the
Well,
case, but why it is before the appropriate.
I will.
bench. Okay. CDB retain, Mr. Sharma, CDB.
Hello.
কৰিলে দিগদাৰ হৈ যায়, এইটো কৰিব নালাগে ন? আমিতো চাফাৰ হৈ যায়।
Item 24.
আৰু কিবা থাকিলে নেকি?
May I please, your lordship?
Yes.
Anticipatory bail petition, my lord, after that CD is called for, my lord. And this is the fifth time, my lord, whether CD is available or not, my lord. The dilemma is.
Yes,
that-
what
My
is
lord, we
there?
have received one report, my lord.
What kind of report?
After that,
After that CD is called for, my lord. The dilemma is that, my lord, only. the one-
Because as per their submission, the petitioners 2 and 3 have privilege ablaze and they were already appeared before the IO.
My lord,
One is
petitioner
already
number-
appeared before the IO, my lord.
petitioner number 1, interim was granted to petitioner number 1, my
But the
lord.
dilemma is that.
Ah,
petitioner
Here in the
was-
my lord 2/4, as per my lord 2/4, my lord, after that CD called for, my lord, statement was not available.
No, whose statement?
Petitioner statement.
May. I,
No,
my lord,
one
clarify,
is granted
Uh,
with
my-
interim.
Yes, my lord. May I clarify, my lord? The petitioner number 1 is granted in interim protections, thereafter he appeared, my lord.
Hmm.
So for the 2 and 3 is concerned, interim was not granted on
there.
that day.
My lord, after
And
that
peti-
CD was called for, my lord, today not received, my
My
lord.
lord, this is the 5th time, my lord, and the dilemma is that 2 and 3 is not in interim, my lord. So may I pray for granting them to interim so they can appear, my lord?
No, it was not
So
granted, not granted.
It is 5th that, my lord. It is not available, my lord.
So what is the reason why after the city is not there?
My lord, in the earlier, my lord, it was 4/2, my lord, it was stated, my lord, it was lying on the district and session judge, my lord. Lakhimpur, my lord. And paid for another that in earlier, my lord. And we have also communicated on 2/4, my lord.
Lying before district and sessions and which court?
Lakhimpur, my lord. Case there is now
So
at
till
order,
they why they could not procure it, today is 24th.
my lord.
Then-
That is
First, it is called for in 27/1/2025. It was not come up, my lord. Then fixed on 5/2/2025.
My lord, we have
On that day,
communicated
CD
on
is not
2/4,
available,
my
my
lord.
lord.
Sorted may be given, my
And
lord.
Then, my lord, 18 to CD is available but not up to date. Again, fix on 12/3/2025, up to date CD is not available. Then fix 1/4/2025. Then also up to date CD is not available and fix today, my lord. And the CD is on that the CD is up to, my lord, 12/12/2024 as reflected in the order of last order, my lord.
Hmm.
So the fact is that, my lord, the petition number 2 and 3 hired the petitioner one's vehicle and purchased some buffalo in Silapathar, my lords. They carried that buffalo. I have annexed those receipt, my
So
lord.
see, your petitions were not granted with the interim in the earlier occasion, so I'm not in a position to grant.
On that day, my lord, if I fairly, my
Well-
lord, submitting on that day, only I pray for interim for the petitioner number 1 because he is the owner, my lord.
My lord, last
On the-
chance may be given, my lord, we'll produce that, my lord. In the
None of the
earlier
other
occasion,
petitioners
he was
suffering,
not
my
given the, my lord. 2 and 3 were not given the, my lord, interim order, my
My
lord.
lord,
No, 2 and 3 are not
That,
in
that's why, my
interim.
lord, I pray for sort that, my lord. I will produce the case there, my lord.
Heard Mr. M.I. Hussain, the learned counsel for the petition. Also heard Mr. B. Sharma, the learned jurisdiction PP, appearing on behalf of state respondent. It is submitted by Mr. Sharma that updated case diary is not received. First of in that context, Mr. Hussain submitted that this is the 5th occasion wherein the updated case diary was called for and the IO could not submit the same. The further submitted, though the petition number 1 is on interim period bail, but the petition number 2 and 3 are not on interim period bail. And accordingly, He prays for some interim protection. Considering the entire submission made by learning counsel for both sides, call for the updated case diary and with a direction to the IO to furnish the updated case diary on or before the next date of listing. In default, the IO may be served with a personal focus notice. And list accordingly. Yes, Sharma,
My lord, that is 8th, my lord.
8 of me.
Only,
8 of me.
only one pair, my lord. If on that day it will not available, then.
Already passed the order, already passed.
My lord, I.
Hmm.
If on that day, if the city is not available, then interim of the petition of 20 may be
We
considered.
cannot pass at this stage, we may consider.
My lord. Let's see on 8/5.
Is on all interim be continued for interim one is petition one.
Petition number 1 is.
Interim be
definitely
continued
considered.
till next date of listing for petition number 1.
25.
The updated one is received.
My lord.
Because
Here,
on
my
the
lord.
last occasion, yeah, return case diary, call for an updated one was there. You have received the updated one now?
My lord. Not up to date, my lord. Here regarding service also, we have received, waiting for service report, my lord.
Oh, service report is also
My
there.
lord. Item
It's the
25.
POXO matter.
My lord.
Oh, service is awaited.
My lord, service is awaited.
And you're retaining the case diary or it is updated?
My lord,
one?
we will have to send back, my lord, because last entry was, my lord. 5/3.
5G. Still you can retain, I think, otherwise it won't reach now.
My lord,
I
it
guess.
will take time.
Otherwise, there are some progress in the investigation. I
Right.
think some statements are there, especially the victims' statements are available. I think.
Right.
So we are going to retain the case.
My lord.
As per office note dated 24/3/2025, the service is still awaited. In that context, additional PP, Mr. Sharma is hereby asked to take instructions regarding the service of notice on the respond number 2. CD receipt, retain the case diary till next date of listing. List accordingly when it can be listed. Because service is there, you can make an take instructions in that
Right.
regard. When it can be,
It may be fixed on 7th or 8th, my lord.
7 May will do.
7th.
27.
May I please, your lordship, my lord. CD was earlier called for, my lord. Whether CD received or not.
My lord, here we have received one report, my lord. They have paid for another debt, my lord.
And you are in interim, I think.
Yes, my lord.
CD not received. IO has paid for another date. Issue reminder,
He was in leave, my lord. I was on leave, my lord.
issue reminder. List the
We
matter
can-
accordingly when it can be
Okay.
listed. 9th of May. 9 can be
My lord.
9/5. Till then, till next date of listings, if extended. Your interim would be extended till
Fine,
next date of
fine.
listing.
9/5.
Not a minute. Okay.
28.
Commissioner on interim.
You are on interim, CD is received.
My lord, city not, 28.
We are on 28.
My lord, here charge sheet submitted, my lord.
Charge sheet already submitted.
My lord.
Yes, CS number
Charge sheet number 3/2025,
3 of 2025,
dated 22/4.
22/4.
2025.
So we are going to extend your interim period till up to 15 days. Appear before the learned trial court below with a regular application for that. Until 15 days, we are extending.
29.
May I please.
Yes.
It was called for prisoners are on interim.
Your petitioner was on interim.
My lord. They have appeared, my lord.
Hmm.
Statement also recorded, my lord. Here, my lord, what happened, my lord, in the one accident took place, my lord.
Huh?
One
What?
vehicle accident took place, my lord, and one police went there, my lord. Public also assaulted the police personnel, my lord. And some of the accused person were arrested, my lord. As per their statement of the co-accused, my lord, he was also there, my lord. assaulting a police personnel. And 2 police personnel injured as per the FIR, my lord. But here is no medical report is available.
Medical report is not available. Yes, what is your submission?
Submission is that, my lord, they have been picked up, their name has been picked up, the one who was apprehended, my lord. He is not in the name of the accused. One, the Vrindavan Sinha,
Vrindavan Sinha.
he has been apprehended by the police in the spot. But, my lord, he has not been enlisted in the list of accused. And moreover, the petitioners, just their names are also not more or less similar, because his name is Antonu Sinha, but they said Batul Sinha. Father's name also not, my lord, similar.
So
Then
you are challenging the identity also.
no, my lord, whimsically, my lord, they have collected the names. My lord. There is a halla in the area, my lord. So villagers, naturally, they have come up, because accident arose there. And all the rank of inspector of police, 4 or 5 police inspectors have arrived at the spot. So there is a chaos, my lord. So villagers have come up, my lord. Whoever names they have collected, my lord, they have killed. Whether they were assaulted, but the FIR says that driver was got injuries. Driver was not assaulted. Driver has got injuries, and another police constable. The others are not. So, my lord, medical report.
Mr. B. Sinha, the learned counsel for the petitioner. Also heard Mr. B. Sharma. As on Sinha, name is there, name is there. So heard Mr. B. Sharma, the learned additional PP, appearing on behalf of said respondent. And it's an application of section so and so in connection with so and so, city received by Mr. Sinha. Submitted by Mr. Sinha that after obtaining the interim order of interim pre-arrest bail, the present petitioner have already appeared before the eye and cooperated in the investigation. He is further ready and willing to cooperate, extend his cooperation in the investigation. Mr. Sinha further submitted that the present petitioner was no way involved in the arrest offense, but his name has been mentioned by some of the co-accused, and on the basis of which the police is searching for him. Next one, Mr. Sharma, the learned additional PP submitted in this regard, that the petitioner had appeared and cooperated in the investigation. However, as per the witnesses, the present petitioner was also involved in the arrest offense. Next one, considering so and so and the conduct of the materials in the case diary. However, he submitted that the medical report of the injured is not available in the case diary. Considered will to the absolute 21/3/2025. Your interim bail dated 21/3/2025 will be made absolute.
Yes, obliged. Highly obliged. Obliged.
30.
Here CD notice in my lord. CD notice in my lord.
Yeah, are you on entry? No.
No. That case, my lord, the alternative medicine from the.
Oh, that case to cannot give the interim.
Subsequently, my lord, all further is carried out, my lord. He has not commonly measured any such major surgery, my lord.
No, as far as I can remember, one surgery was done by him, most probably in the someone sustained some injuries or wherever in the leg of
case
one
is
leg.
that, my lord, one person, my lord, submit a complaint, filed a complaint before the health district health officer.
One leg surgery was done by him, I think. So
Only
in that
up-to-date
case-
case diary will be updated, no, up-to-date case diary.
Is there not
I know.
received issue reminder? List when it can be listed, Sharma?
Was I married? Definitely my
Muraja.
was I married? That my lord, 9th my lord.
No, let Malik up-to-date case
Yes,
diary.
updated case diary be called. Okay, we'll see.
Right.
32.
Meet legal.
Case
You have to
diary was-
receive the CD.
CD notice in my lord.
Are you on interim, Mr.?
No, your lordship.
22 CND.
22 CND paste to definitely CD will be required.
Otherwise, the case which I am projecting is that the vehicle was given on rent to another person. And thereafter, I'm from Uttar Pradesh and the vehicle was caught at Sribhumi. Sribhumi. So I was never in control of that vehicle as that was already given on rent prior to 1 year from the date of.
But was there any these secret chambers and all for carrying those
No, it
contraband
was
and all?
hidden. It was hidden under some onion bags.
Onion bags?
Yes. So I'm apprehending that once I go there to take Zimma of my vehicle, I may be arrested.
Oh. When can be city should reminder period, city not received? When it can be?
See, we will take time, my lord.
13th month, 1-3.
1-3. Your petitioner still is in Uttar Pradesh?
Mm,
He's safe there?
He's safe there, but I'm not updated. Lordship may protect me till the next.
He's NDPS case.
13th. Okay, by listing up.
Obliged.
33.
My lord, here service report awaited now.
Hearing already. Okay. Otherwise, we have received the scan copy. Is the scan copy is required?
Scan copy, my lord.
But I'm not positioned to hear the matter.
My lord.
I'll just take 1 minute. Your lordship.
No, I'm not.
We have also
here.
not gone from my lord. That's a
No, I'm
service
not
report
going to
awaited
hear
as
the
per
matter.
our.
You have already appeared? So we'll fix a date then. You are Mr.
TL Oscar, your lordship.
T.L. Oscar. Heard Mr. T.L. Oscar. The learned counsel for the petition and also heard
That's
Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. And Mr.
M. Hussain on behalf of D.K. Agarwal.
M. Hussain appearing on behalf of Mr. A.K. Agarwal. D.K. Agarwal for the respondent number 2. You are not an amicus. Scanned copy of the case record has already been received. List the matter for bail hearing on. Five can be given, 5, 6. What to do? We don't have any alternative. To say AB only 5, 6 can be given.
My AB, my lord.
7.
Much obliged.
34 for hearing.
Yes.
Time will not permit, lordship.
So we are fixing a date here. You are for the petitioner
I'm for the petition.
and Mr. B.P. Bora
B. Bora.
and Mr. P.J. Datta is also there.
They are for the respondent number 2. It's an
They are
NI
for
Act
respondent
matter.
number 2. Pardon?
It's
NI.
an NI Act matter. NI Act.
So
The
state
does not
is
have a
not there.
We have no.
Just a
No
formal
party,
party.
you're just a formal party.
Formal party.
So we are listing it on any hearing day, okay? A hearing day at a subsequent kundina. You have attended all marriages on month of February?
February, lordship, I was tired. Now I'm having health issues, but I'm just putting on somehow. I have an appointment with the doctor in the evening.
Oh, today evening?
Today.
Okay. Health issues are with every one of us.
Everybody. So we can't
We
stop
all are
working.
having health issues. What to do?
We can't stop working.
We can't stop working. Me also, I have health issues. He also must have health issues. What to do? Yes. 20 will do for you?
Yes, lordship.
20th of
Yes,
May?
lordship.
20. See, I can still remember your submission that you have
Lordship, that day,
patterned.
I did not want to tell any lies to the court. That is why I came up with that.
Yes, I can still remember because in the month of February also, frankly speaking, we had also several marriage things involved there
Yes,
also.
lordship. And for me, the major trouble was my sister, she's having a kidney problem. So she could not attend any of the weddings. And all the rituals which are supposed to be done by a daughter have to be done by me in her absence.
Oh, Acha.
So I didn't have any other option.
These are the responsibility you have to be around.
Yes, lordship.
It's fine. You are getting the masters. No, sorry, I mean doctorate in law.
In law.
In law. From where?
Mahatma Gandhi University, Meghalaya.
Achha.